Welcome everyone. My name is Thibault Schrepel. I'm an associate professor of law at the Wright University Amsterdam, and I'm extremely pleased to welcome you to this Blockchain plus the Law conference. Before I explain to you why there is a plus in the title of our event today, and before I introduce our speakers, I do want to mention the VU Interdisciplinary Centre for European Studies and the Amsterdam Law Technology Institute, ALTI. In fact, this conference wouldn't be possible without them. And today's conference is the very first we are organizing with ALTI. And so we are currently planning some more, and I will put the link to the newsletter in the chat in case you are interested to stay updated. We have received over 1,300 registrations. That's a lot. Thank you very much. It means a lot as well. If you want to tweet about the conference, you can please use the hashtag ALTI blockchain. I will put it in the chat in just a minute. And now I am extremely pleased to give the floor to the Dean of our law school for some welcome remarks.
Thank you, Thibault, and greetings. My name is Hemme Badjes, and I'm the Dean of Vrije Universiteit Amsterdam Law School. And I'm very pleased to welcome you to the Blockchain plus the Law conference. We've passed 1,300 registrations for this event, and I'm pleased to see so many of you today. I think it's fair to say that our two panels are quite exceptional, but before we get started and I give the floor back to Thibault, I would like to point out that this event is just one of many activities in the realm of law and technology deployed by our law school. But instead of offering an exhaustive list of all the research, teaching and events like this, I would rather refer you for more information to the website of the ALTI, the Amsterdam Law and Technology Institute, Thibault mentioned already. Now back to this event. During the next 4 hours, our panelists will explore the plus we have put in between blockchain and the law in this conference title. They will discuss whether law and technology can and should be combined, how law can help technology, and vice versa. The subject is extremely timely, as you know. New blockchain regulations are coming in Europe with Makan in the United States, where there are talks about regulating blockchain consensus and all over the world. I'm pleased that we are taking the lead on the subject by organizing today's unique event with top officials and academics. Thank you.
Well, thank you very much for the kind word and the stimulating introduction. I do now want to give the floor to Professor Davis to talk about the educational programs, and so maybe also about ALTI and what we do in the field of law and tech. So Gareth, if you will, the floor is yours.
Thank you very much. I'll be brief because everyone wants to get onto the content, but I just want to welcome everyone also on behalf of the Department of Transnational Legal Studies, which I'm currently the chair of, and that hosts European lawyers, public international lawyers, and of course, internet and technology lawyers, of whom Bo is a very important member. And we're really pleased to be able to host so many of you for this conference. We couldn't have got nearly so many people to Amsterdam. It's great that you've all managed to be online to join in this conversation. For us, this is a very important field of law. We have 2 master's programs in Dutch and in English on internet law and technology law, which attract a couple of hundred students a year from the Netherlands and all over the rest of the world. And we're excited to be developing this further with ALTI and with our team of internet lawyers. I'm also on the board of VICES, which Thibault mentioned, the VU Interdisciplinary Centre for European Studies. Although this isn't a conventional EU topic, it is quite important to us. At VICES, we're looking for new perspectives on the European Union. And what's interesting about the blockchain is it's not just an ordinary object to be regulated, but it's something that invites the regulator to think about big questions such as what kind of economy do we want to have, what kind of society, and what is the role of government in that society. And these are very important, even perhaps existential questions for the European Union. So thinking about blockchain perhaps has something to add also to European studies. I certainly hope so, and I look forward to hearing as much as I can before I may have to leave of this afternoon's discussion. Welcome, everyone.
Well, Gareth, again, thank you very much. I think you used the word existential, and so of course we're going to provide all the answers that you may need to solve an existential crisis or potentially an existential potential. I do want now to mention why there is indeed a plus in the title of today's conference, and take 2 minutes to explain that, because I think, as you will witness today, I do have plenty of questions for our speakers, but I think it's fair to say that they all come down to one interrogation. Could we, and potentially should we, combine law and technology instead of opposing them? And I believe that the answer to this question should be positive, but that's something to be debated, of course. To be concrete, when using law plus technology, or here blockchain plus the law, we mean two things. One, we want to understand the potential and benefits of a technology so that when we tackle the problems it creates, we can compare which solutions preserve these benefits the most and adapt and adopt the best in this regard. This idea here is, when possible, not to reduce a technology capacity to improve the common good when tackling the issue. That's objective number one. And two, I believe that combining law and technology can help reaching better legal outcome than simply applying the law of its own. Think blockchain and antitrust, something we'll discuss in the first panel. They both seek decentralization, but as you may know, they seek to achieve decentralization in a totally different way. And those, I believe, are complementary ways. So in short, today's objective is to study how we could tackle the problems created by blockchain while maintaining its dynamism and attractiveness. So this is why I have defended and explored in a book entitled Blockchain Plus Antitrust that came out last October. I've already put the link in the chat. It is open access, so feel free to browse it freely. But now it's time for me to mention and to introduce our first panel with indeed top officials and academics. So I'm very excited about today's conference. The first panel is dedicated to blockchain plus antitrust law. It will last 2 hours. The second panel is dedicated to blockchain plus regulation. It will also last 2 hours. With that in mind, I have a good and a bad news for you already. The bad news is that there will be no break between those 2 panels, which I think is fair to say is mostly a bad news for me, because I'm the one who can't live while you can actually go for a coffee behind your screen. The good news, and I'm surprised we haven't received the question yet in the chat, is that today's conference is being recorded and will be published on the Amsterdam Law Technology Institute website in just a few days. So without further ado, let us get started. I welcome our first panelists, who are, for the most part, on the screen right now. We do have, and we're still waiting for him, but we should solve the issue in just a minute, Commissioner Noah Phillips, who is serving at the Federal Trade Commission since April 2018. I think it's important to mention that Commissioner Phillips has been unanimously confirmed by the US Congress for the position. We also welcome Professor Frédéric, who is the chairman of the OECD Competition Committee since 1994 and a professor at ESSEC Paris Business School. We welcome former Assistant Attorney General for the Antitrust Division, Makan Delrahim, who is now a member of the board of directors at Osiris Acquisition, and who recently published a piece in the Wall Street Journal. I will also put the link in the chat, entitled "Regulation Will Be Good for Crypto." We welcome Professor Tina van der Leyden, who teaches and researches blockchain law here at the Wright Universiteit Amsterdam, and who, I think very interestingly, started her career as a computer programmer. And last but not least, we welcome the chairman of the Dutch competition agency, Martijn Snoep, who is leading the institution since September 2018. The panel is organized as follows. Each speaker will be given 7 minutes to introduce her or his thoughts on the subject. I will then ask them questions divided in 2 separate sections. And finally, I will open the floor to the audience. If you do have questions, please put the questions in the Q&A function, not just in the chat. For security reasons that you will understand, we have disabled your cameras and microphones. But if you put your questions in the Q&A, we will try our very best to answer them all. Commissioner Phillips was scheduled to be first, but no worries. We have to be dynamic and to show dynamic capacities here. So we will get started with Frédéric for his introduction. Frédéric, the floor is yours.
Thank you very much, Thibault, and welcome to all of you. Let me start by saying that digital competition issues have been a long-standing theme at the OECD Competition Committee. And a particular sub-theme of this work is identifying new developments such as blockchain technology and their implications for competition law and policy. So in 2018, the committee held a hearing on the topic of blockchain and competition, and Thibault was part of that panel. And the OECD Secretariat continues to provide a competition policy perspective to the broader work of the organization on blockchains. Now, what I would like to do is to make a few points about the implications of blockchain technology for competition policy, starting from some of the key features of this technology. First, probably the best way to look at blockchains when one considers the issue of competition is to consider them as platform products that compete to attract both users and validators. The success of any blockchain, therefore, relies on its ability to attract users who use the blockchain to validate actions and to attract validators who collectively do the work of validating those actions. Now, clearly, the pricing of the validating services will be one of the keys to the success of the blockchain. The second thing is that when considering the implications of blockchains for competition, I think there are different levels that we should have in mind. First, the actions by the users of the blockchain, for example, firms which are competing on the downstream market. Second, actions by those who control the protocol of the blockchain. Third, actions by those that sell inputs to the blockchain, such as hardware, software, developers of validation and hardware of software. Naturally, another level is actions by rivals to the blockchains, which may be or may not be other blockchains, and this may be of interest to competition. Third, the blockchain reduces the intermediation cost, and we should keep this in mind. This is clearly a key benefit of many blockchain applications, with implication not only for economic efficiency, but also for economic inclusion. Blockchain may open up access to products and services to a wide range of new consumers, including those outside of existing banking and financial systems. Fourth, the transparency, which is at the core of blockchains, particularly public ones, can give rise to significant risk for competition. On the one hand, as I will mention in a minute in more detail, it can make collusive agreement easier to reach and to monitor. The perfect transparency of some blockchains may even do away with the need for collusive agreement altogether and allow tacit collusion to be the norm, particularly in concentrated markets. Similarly, collusion can facilitate the impositions of vertical restraints, allowing any deviation from pricing limitations or exclusivity agreements to be easily detected. On the other hand, we must recognize that transparency may also be used to the advantage of competition authorities themselves. We are seeing within competition authorities growing interest in the use of price screens and other tools of similar nature to identify potentially anti-competitive conducts. And we're also seeing that blockchains could be used to monitor compliance with remedies. So one of the key questions is whether agencies can gain access to a blockchain for these purposes or can set up blockchain to monitor remedies. Fifth, smart contracting gives rise to many of the same opportunities and the same risks that I have described about transparency when it comes to competition and blockchains. They may create automatic mechanism for punishing firms that deviate from a collusive agreement or the vertical restraints set out in a supply contract. But they may also be used to implement competition remedies in a resource-effective and easily verifiable manner. Sixth, decentralization is, of course, a key aspect of the impact of blockchain technologies on competition. Highly decentralized public blockchain are less likely to give rise to competition concern than permission blockchains. Further, the remedies are much more complex to design and to enforce for decentralized permissionless blockchains. But there can be a concern that the validation of a permissionless blockchain may over time lose its decentralized nature and become more concentrated. And that would be the case, for example, if a validator, which has a huge capacity, using other validators in what is known a mini pool might be able to change the protocols of the blockchain and to, for example, raise the price of the services, either unilaterally or in coordination with a small number of other validators. So even though those permissionless blockchain are not the core part of the antitrust concern, competition authority may wish to keep an eye on the degree of concentration of validation capacity on any permissionless blockchain that would hold market power if they were centrally controlled. Now, if we come to permission blockchains, concerns may arise about abusive conduct by the members of the consortium that operate the blockchain, because these permission blockchains are perfectly capable of exercising any market power that they have. Indeed, there may be particularly strong effects in the increasing number of industry blockchains that are being formed by consortia of upstream or downstream firms that serve a certain markets. And we can think there of what happened in shipping or what happened in diamonds. And also in the case of blockchains that serve a broader set of markets. And I have here in mind, for example, the Libra blockchain. Typically, user will use pseudonymized, user will be pseudonymized, but transactions themselves will be transparent. Now, if an industry blockchain was to set excessive transaction price, this might potentially be challenged as an exploitative abuse of dominance, keeping in mind that since blockchains are platforms, price cost tests, which are usually used in antitrust, are not fit for purpose, and the OECD has been doing some work on that as well. There would be a risk also of collusive agreement for three reasons. First, the meeting of rivals through the blockchain consortia might facilitate information exchanges or discussions that affect the price setting behavior outside of the blockchain, for example, on the downstream market. Second, a blockchain offers a cheap and reliable way for firms to commit to a course of action, let's say to pay a lump sum to a third party in the event that certain criteria are met. This commitment device can be useful for pro-competitive purposes in some cases, for example, to solve hold-up problems or to verify the absence of free riding. However, they might also allow firms to soften price competition. For example, they might allow firms to commit to a price by making it costly for the firm to move away from that price unless certain criteria are met. So they might also help monitor and verify movement in other factors that drive pricing decision and which might otherwise disrupt explicit or tacit coordination, such as, for example, weather patterns or input prices, or to make side payments. In particular, it is notable that common ownership of blockchains raise issues which have been raised of other institutional investors, and they may arise. And one good example of this was, in fact, the Libra blockchain. The third reason why blockchain may facilitate anti-competitive behavior by users is the greater trust in the authenticity of the transaction and the prices on the blockchain. They give better visibility and confidence in the veracity of any deviation from the collusive outcome that occurs. So there are reasons to fear collusion within the blockchain. Alternatively, the consortia might collude with other blockchains or non-blockchain-based firms to divide market by geography or by type of applications, or to slow the speed of the development of a blockchain. Finally, there might be a concern with exclusionary theories of harm. I'm not going to detail those because they are fairly classical. One might envisage the fact that blockchain could engage in predatory pricing that forecloses rival blockchains, that they use loyalty or exclusivity rebates in order to raise rivals' costs, that they may resort to tying or bundling the blockchain services with other products or platforms in which some of them are dominant, some of the owners of the blockchain is dominant, etc. But there are specific issues related to the blockchain that we should keep in mind. Consortia may adopt measures to prevent users from porting their historic data stored on the blockchains, and for example, their data on their reputation to rivals, or measures to prevent the development of interoperability between the blockchains and their rivals. And when we had the hearing I was mentioning at the very beginning, it was pointed out to us that portability between blockchain would be highly desirable, but it was unlikely to emerge spontaneously. Consideration would also need to be given to the possibility that the consortia might exclude downstream rivals. If an industry blockchain, for example, were to become a standard or an essential facility for firms operating in that industry. Let me finish by saying one thing. The OECD has always emphasized the need for regulatory frameworks that are technologically neutral and which do not unnecessarily restrict new entry. In the case of blockchains, we have a new technology, we have regulatory attempt, we may also have lobbies that try to protect themselves from this innovation. And we must keep in mind, as I said earlier, that this is an innovation that reduces transaction considerably. So competition authority probably also have an advocacy role in making sure that they advocate for regulation that allow blockchain technology to deliver its best potential. Thank you.
Well, Frédéric, thank you very much. You mentioned quite a few times the Libra blockchain, which was announced to be a dead project as of last week. And it's very interesting because it shows that indeed the regulatory pressure that we could put on blockchain may also have an impact even before the product hits the market. And you covered so many of the practices and the things that I do want to cover in my questions. So thank you very much. I will now give the floor to Makan for his thoughts on the subject.
Well, good afternoon over there, and thank you so much for inviting me. It's particularly great to see some of my former colleagues from the enforcement community, Martijn and Fred, who for many years we have worked together to try to do our best to improve the world of competition, especially through the international cooperation as the digital world changes and makes our world much closer in the economy. Well, I thought I would start off. Some of you might recall I'm a big fan of music, and I thought this particular topic, both as a tribute to you, Thibault, and also to the topic at hand. I'm a fan of that old song by Dire Straits in 1982 called Telegraph Road. And the song, as you may know, is about a pioneer who makes a home in the wilderness. His entrepreneurship and hard work attract other people, and he soon finds himself in the midst of a bustling town building up around him. The lyrics of that song describe the onslaught of infrastructure. And here's the lyrics, which I will do without any musical notes, but it goes, then came the churches, then came the schools, then came the lawyers, then came the rules, then came the trains and the trucks with their load, and the dirty old track was the Telegraph Road. Well, I think this transformation is an apt metaphor for the history of the economy, but particularly for the transformation that blockchain is doing to the digital economy, both in the US, but abroad, and its potential. And I thought it was particularly apt because of the part about lawyers and rules, the subject germane to this topic. And I commend you for this impressive conference and your contributions to the literature and your book. As I just saw from the various chats, you have participants, from Argentina to Jerusalem, to Singapore, to places all over the world that have assembled. And as the Dean mentioned, You have over 1,300 people who have gone in. So I don't need to belabor the point about what blockchain does, but how it relates and how we see it affecting competition in the United States. It is without question that blockchain technology, the underlying technology, and I'm not talking about just the application with cryptocurrencies, its application has the potential to transform the entire economy, multiple aspects of it, not just the transfer of money, although that's a very key component as well. We have seen wide-ranging impacts of these types of general purpose technologies that have affected our economy throughout the history of our economy. These technologies have been railroads, electricity, telecommunications, and the internet itself over the last 20 to 30 years. Each of them have played a very important role in the evolution of our society, and each has spurred incredible innovations that have fundamentally altered our ways of life. These technologies, importantly, carried the promise of toppling existing monopoly structures, as well as the prospects of new monopolies emerging and seeking to entrench themselves. And that's what our role as students of competition and enforcers of the competition rules themselves, that's where it plays in. I think blockchain holds a similar promise as the foundational technology, as these other technologies have had, with the added potential to maintain a more decentralized marketplace. As we have seen, I think the CEO of Newmine, Ibrahim Al-Cord, he explained blockchain as a ledger of transactions that is distributed to computers all around the world. The ledger automatically updates with every transaction and can be viewed by anyone at any time. And this means that you have a potential for not only pro-competitive, but at times even anti-competitive conduct, because it makes activities much more transparent through the ledger. And that's the other side of blockchain that we as enforcers need to be mindful of, making sure that it is not used as a tool for the types of collusion we might see. I think we have seen now important applications that have come about with different business models using blockchain that are toppling important incumbents. As I mentioned in the Wall Street Journal article or the op-ed, Filecoin is an example that offers decentralized cloud storage that could compete directly with the market power of Amazon Web Services and other providers. Another good example is Helium, that offers decentralized wireless communications infrastructure. And then there's a whole host of other offerings like Catalog and Digimark and others that are being used and applied to the royalty and intellectual property management system to create efficiencies. You mentioned the potential of blockchain plus antitrust, and a main potential of that is, I think the transparency and the utilization of things like smart contracts to create and reduce the friction amongst people where you have a dispute over rules and the law. And they allow for the immediate transactions and reducing the types of frictions that give rise to antitrust laws and to legal disputes and lawsuits. And the technology could immediately allow for greater efficiency and in transactions. I think it also allows for predictability. One of the hallmarks of at least the laws in the United States is to have as much advance notice about what the rules are, have predictability in the judiciary system, and have as much transparency in that. And here, blockchain has the great potential to be a real disruptor. We have seen the applications have profound implications for industries, from financial services to credit monitoring to health insurance, to, as I mentioned, some of those examples, to intellectual property management, and they're very important. One of the important aspects, however, is what the rules of the road will be for the development of blockchain. There's a major debate happening in the United States about the regulations and what the regulatory environment will look like. There's some uncertainty. There's a very important case about whether or not securities laws can apply to the issuance of coins, and that is going on right now. And it might be resolved over the next year, but that will have a big impact of certain aspects of blockchain. Various parts of the U.S. government and internationally are trying to tackle that, and having some resolution and some predictability about what the parameters are will either unleash the great potential blockchain has, or it will limit it. We have a free market to the extent the markets are defined by various governments through rules that are imposed on them, and the incentives and disincentives for the deployment of those technologies. And I do hope that as regulators of different aspects of blockchain technologies consider very prominently the competitive aspects, the pro-competitive aspects of blockchain as a counterweight to any potential downsides of it. And rules are crafted in a way that harnesses the very important pro-competitive applications that it could have. And while you're putting in rules to minimize any downside, protect consumers, protect investors, of course, those are all necessary components of a free market system. But you don't want to choke the very potential. And it's really important for policymakers, whether in Congress or at the Treasury Department or the Federal Reserve in the United States, or our partners of any of those agencies, and of course, the antitrust authorities, the Federal Trade Commission and DOJ, to really understand the potentials for this technology. So I'm looking forward to the debate this morning. I commend you and our colleagues for assembling this discussion, for continuing to advance the know-how in this field, and making sure that whatever rules we put in, whether it's in the US, in Europe, in China, and other parts in Asia or Latin America, because of the interconnectivity and the potential pro-competitive and efficient offerings and features of this, that the rules we put in are the best rules that ultimately protects not only the consumer, but the innovative efforts of all the folks that are continuing to build on this telegraph road. I thank you, and I look forward to this debate.
Well, thank you very much. You triggered quite a few comments when you quoted Dire Straits in the chats. I know which music I will listen to tonight when celebrating the end of this conference. I'm also very pleased to welcome Noah to this panel. It's always a struggle when you organize a conference about blockchain and complex technologies. If you can't actually bring all your panelists and make Zoom work as it should, it's quite a struggle. So I'm very pleased to see you. I will give you the floor in a minute, but first we're going to hear from Tina. about her thoughts on the subject, and then this will be your turn.
Okay, thanks, Thibault. I didn't quite see that coming yet. Being a teacher, of course, I have prepared a PowerPoint. Yeah, so thank you for inviting me to this wonderful panel, and I'm, so excited to see so many people from all over the world. This is truly amazing, and it is amazing that well, technology enables this now, right? Even if some of us have some struggles in connecting or in showing their slides, whatever. Okay, so my brief presentation. As you know, I do not really know much about antitrust. So I was a bit surprised that you put me in this panel instead of in the next panel, but yeah, hey, I can deal with it. But I was helped by a comment in the chat just now, a few moments ago, by Mehmet, that blockchain is not, well, I mean, your book is Blockchain and Antitrust, but there is also a book about how blockchain is the new architecture of trust. The book by Kevin Verbach, which I just finished reading for the second time this morning. So what I'm interested in is this, well, this dual meaning of trust, antitrust. And Verbach in his book explains that trust comes from confident vulnerability, as the younger child in the picture, to presupposed trust in fiduciary relationships, and then it evolved to, well, meaning a monopoly, but that is only 150 years ago, say. Sorry, my cat is getting very annoying. He starts biting me in my feet. I just 1 second.
No worries. In the meantime, I can say that, what's fascinating with the subject is that indeed antitrust, to be clear, if you're not an expert, by trust, we mean the trustees, the big corporations.
Yeah,
and
sure.
Yet, blockchain may bring a different meaning because it creates so much trust about organizing potentially a cartel that it might be that antitrust will become trust in the sense of interpersonal trust. But please go ahead.
Indeed. Well, the cat has left the room. So let me see, where am I? Yeah, so there is a connection, right, between trust and antitrust. And well, as you explained, Thibault, in your book and also in the 5th video, both antitrust law and blockchain have a common goal, which is decentralization, but then not as a goal in itself, like not the outcome, but the process, right, of decision making and of, transacting and doing things. Yeah, so that is why this is so interesting. So I want to focus on, well, trust, what it means, but also I want to say something about your law plus tech approach, because that is, of course, also very thought-provoking and appealing as an idea. So what you explain in your book, and also, well, in almost everything you say, is that we lawyers should not, be afraid of technology or focus on the harms it can cause or focus on its downsides, but we should embrace it, right, for the common good, which I totally agree with. However, I do also feel that we need to, keep up our own values, and not all technology is good by definition or by itself. On the other hand, I also think that technology should embrace law. And Well, we may have a problem there. And this is what I think Werbach really explains nicely in his book, that for the human part of cooperation, we cannot do without law, however cool cypherpunk rhetoric may sound. And also that not all law is bad, outdated, unfair, inefficient, etc. But then, of course, this is us speaking, right? We are lawyers, so obviously we think law is worthwhile, law is important, and law is good. Well, for the so what should we do as lawyers, right? Because we can only determine our own course of action. What does it mean for us lawyers to be embracing blockchain, or, well, embracing technology, but in this case, embracing blockchain? I think it is important that we understand the technology at a functional level, right? So we do not necessarily need to know all the details or be informed and, experts on everything, but we need to be able to talk to technical people, and we need, well, to understand how it works up to the level that we can advise, for example, startups or people dealing with blockchain issues. As I said before, we need to embrace technology, but the techies also need to embrace us, so to speak, which means that we need to reach out to them and we need to educate them a bit. And we need to do that carefully, because we do not want to be too paternalistic, and know what is right for them and what blockchain needs and blah, 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 because then you evoke resistance straight away. And I think what is particularly important here is then the notion of governance and the need for governance. Because, well, talking to people from the computer science department, I found out that they feel that they don't need law at all. And that also governance of blockchain can best be organized blockchain internally, which I, of course, very much disagree with, but I have a hard time convincing them. That is what I'm doing. Also, in order to be able to trust smart contracts as lawyers or as the clients that we advise, I think we should be able to read them and understand them and make sense of them. And maybe for some of us, that even requires that we are able to code them. So when I, for the first time, started the blockchain course at our university 3-4 years ago, I played with the idea to put some coding practice, but then it was too difficult, and yeah, so I didn't do it. But yeah, maybe we can talk about that at some point. Yeah. Then lawyers also need to facilitate use of blockchain and blockchain applications, like define the legal status of crypto assets, as the proposed markets in crypto assets regulation tries to do. We need to support blockchain-based cooperation. For example, we have just seen a very nice master thesis on the implementation of the conflict minerals regulation in a blockchain supply chain. We need to, well, accommodate, support, and deal with distributed autonomous organizations. And finally, we need to prevent and correct abuses of power, which is where antitrust law comes back in. And not only to regulate it, but most importantly, maybe to be able to enforce it. And enforcement is always the big problem. Right. So what we need to do, we need to educate lawyers, and we need to do research, which happens to be exactly what we do at the Amsterdam Law and Technology Institute. So that was it. Thank you for your attention. This is the road ahead. We don't know where it leads to, but it's nice. Let's go. Thanks.
Well, thank you very much. As you just mentioned, indeed, there are much uncertainty, and one could say that it's actually the goal of antitrust to inject uncertainty in market as to how to capture profits. Mm-hmm. So thank you very much for this. Noah, the floor is yours. If you're still with us. Yes, I can see you.
Can you hear me okay?
Yes, it works perfectly.
Terrific. So my apologies to everyone for jumping onto this late. I was having some Zoom issues, and my thanks to all those who helped. Among other things, I missed Fred's remarks, and Fred Jenny is always a person to listen to. So my apologies that I'm not aware yet of what he said. My thanks as well to Thibault and everyone. It's a great group of people. I'm glad to be here, and thanks to ALTI. I also have to caveat what I'm going to say is just my view, not necessarily the view of the Federal Trade Commission. And lately, there tends to be a little bit more disagreement. For those of you who are not from the US or familiar with our structures, just so you know, we have two different antitrust agencies. One was recently run by Makan Delrahim, who was speaking earlier. That's the Department of Justice. And the other is where I work, which is the Federal Trade Commission. And we do both consumer protection, which includes privacy, where we've actually done some blockchain-related enforcement, and also we do antitrust. Among our remits are to study markets and in certain regards, although specific regards, regulate. Tina, I have to say, the first time I ever delivered a paper, and really the only time I ever delivered a paper in an academic setting, was not so far from you over in Belgium at Leuven, and it was about conflict minerals. So that was quite an echo for me. Okay, the question I want to start with is how do we and how should we in the US look at blockchain from the perspective of an antitrust enforcer or regulator? And Makan alluded earlier to the Ripple case and the ongoing discussion in the US, where most of the regulatory concern with blockchain is about cryptocurrency. And there are a number of very live discussions. So should the US have a stable coin? There is some indication that we're going to have a national policy on cryptocurrency coming out. And of course, there's the Ripple case, which addresses the issue of under what circumstances a coin is a security and should be regulated by our security regulators. But from an antitrust perspective, to me, the cryptocurrency applications of blockchain are much less interesting. It's these other applications in different kinds of markets where we're seeing blockchain use that ought to draw our interest, our attention, and also, as you've heard from some of our speakers, our care. Because if we regulate the wrong way or foolishly, we may chill innovation. And to my mind, that would not be a good thing. And it is critical, as Tina was saying, for regulators to understand how blockchains operate, right? What are their rules? And then what are the applications? Where is blockchain being used? And as you've heard earlier, the number of different applications, beyond the original Bitcoin application are really spreading in great numbers. To my mind, approaching this from a perspective of fear of what we don't understand, and regulating first and asking questions later is a recipe for bad outcomes, for the development of markets, for innovators, possibly for the unseating of some large incumbents, really for consumers as well. And I think that kind of perspective, where we think about the costs, but also the benefits, is really critical. And you've heard a lot of this already, so forgive me if I'm rehearsing what folks have said. Fundamentally, right, blockchain decentralizes power, and the concern at the heart of antitrust is some of the bad effects that can come from centralized power. And Thibault alluded to the sort of the 19th century trust that animated the nomenclature that we use in the US of antitrust. Those are arrangements under state law. And that's a critical thing to start with, is that we're starting with a force that cuts against the, one of the animating concerns of antitrust. The second thing is the elimination of inefficiency. So how does trust operate in an economy? You can think of Francis Fukuyama's book from the 90s, Trust. You can think about those wonderful studies conducted of the diamond trade of Orthodox Jews in New York and Belgium in particular, where they don't even need law, or at least they don't need civil law or contracts. Mutual relationships of trust operate as a terrific heuristic. You can deal with this person, and your word is your bond, and this sort of thing. So where we have markets operating, we have law, right? We can have code, and that's doing a lot of work here, but cultures that either supplement trust or operate where trust does not need to operate can produce terrific inefficiencies and allow folks to trade. Where it gets undermined, you can have things go the other way, but I think that's an important, I just see someone commented, halakha, yes, above the law, for sure. And of course, blockchains can also lower entry barriers, right? But what's the cost side of the ledger? Critically, as Thibault notes, a blockchain is not a firm. And so there is an accountability problem that inheres in blockchain. And there's also, what I think of a lot as a law enforcer, there is a visibility issue, right? There is anonymity, and that anonymity can be very important, but it creates an evidentiary issue. Certainly there are ledgers and there's a paper trail, but we may not be able to see, and it's immutable, but we may not be able to see what's going on as well as we might in another context as enforcers. And those are things we need to look out for. Thibault, how am I doing on time?
You have 2 minutes left.
Okay, I'll do this. The biggest thing that jumps out to me from an antitrust perspective is how a blockchain might facilitate cartel activity, both in sort of setting prices or dividing markets, but also in policing them, and what role smart contracts could have in doing that. And I think if I had to pick one issue, it would be cartel or cartel-like behavior or facilitating further tacit collusion that we would look out for. If we move over from the Sherman Act to the Clayton Act, when we're looking at a merger, if we're looking at a market where blockchains are used and there is a concern about coordinated effects, that is not just the limitation of competition between the merging firms, but also how the new market and how it operates might facilitate collusion. Blockchain might be an area at which we want to look to understand how it's working. There are also potential monopolization concerns, but I would humbly submit, since we have to say that there is a monopoly to begin with, those may be further out at this point. I want to finish with some caution that we've heard from other speakers, which I think is particularly apropos in the context of the new American administration's approach to regulation. Where we are today in the US is we have sort of a regulate first and ask questions later mentality. There is an idea that the federal regulators have complete information. We don't. And there is a view that we also have authority to regulate pretty much everything in front of us. I don't think this is a good idea. I think we need to understand that part of what has allowed technological innovation to occur, allow markets to grow, is taking a more careful touch, understanding first what we are regulating, moving from facts and not fear. And I think that is probably as good a place to end my remarks as any. And I'm looking forward to the conversation. So thank you.
Well, thank you very much. I was reminded of a survey that I saw, I think this morning on Twitter. I think it's a PEW survey, and they ask Americans, what do you think has contributed the most to improving the common good over the last 50 years? Or something like that. And the number one thing is technology. But then, of course, the question is, maybe it's also technology because it was shaped by regulation eventually in a way to improve the common good further. So I think this is the tension that we need to solve. I want to remind everyone in the chat that please use the Q&A function if you do have questions. I've seen your question, Balash, so I've been asking the question. But without further ado, I've kept the Dutch perspective. So Martijn, thank you very much for being so patient. And the floor is yours.
Yeah, thank you very much, Thibault, and thank you very much for inviting me to the splendid panel. I think a lot of the things that I had in mind were already said. We had a fantastic, what I would say, policy perspective from Frédéric and from Makan. I think Tina gave a more, how would I say, philosophical perspective on the issue. And Noah really resonated a institutional enforcer's perspective. Of course, obviously from the US, and what I'll try to do is to give you a bit of a similar perspective from the Dutch Competition Authority, which is, as some of you may know, many probably don't, is an independent government agency within the Netherlands. We enforce EU competition law and Dutch competition law, which are identical, in the Netherlands. We are part of what is called the European Competition Network. So together with the European Commission and the independent competition authorities of the other member states of the EU, we enforce jointly the European Competition Network and try to come to have a coherent enforcement policy within the European Union. We are, and like I said, an independent agency, but that also means that we are not accountable to the legislator. I was appointed for a fixed term of 7 years. I cannot be dismissed unless for grave misconduct. I'm not a political appointee. It was just I would say a merit-based appointment by the government, and I cannot receive instructions from the government. But that independency also comes with I would say with a price, in the sense that what we can do as an agency is strictly bound by law. We cannot go beyond the laws, and most importantly, we do not create laws. So we have to be careful when using, from our perspective, from using the word regulator. We cannot make rules as traditional regulators can. Now, we enforce the competition rules, and that gives us a limited role. I see in the chats and in the comments calls for better regulation, smart regulation, and there we have a very limited role. Our role is limited to that of advocacy. So what we do, we study markets, we look how markets function, and can put in recommendations to the legislator to make rules, to make markets work better if we find that these markets do not work well. So this is where we are. That doesn't mean that we are completely inactive in the area of blockchain and antitrust. In 2018, we conducted an internal study on what blockchain technology would have an effect on our oversight duties, and in which sectors of the economy we saw the most rapid development. And I think at the time, we saw already, well, like many of us, that the financial sector was probably ahead of many other economic sectors in adopting parts of blockchain technology. And we saw at the time also potential for the energy sector. We also looked at potential market failures as a result of blockchain technology. And I think many of those have already been discussed. Most importantly, I think the creation of market power through cartels or other conduct in markets. We also saw the threat of lock-in effects, where customers are locked in with one supplier and cannot leave that supplier for a long period of time or for eternity, having negative effects on prices, quality, and innovation in the market. But to be honest, I talked to a lot of people within the agency in preparation to the conference, Since 2018, I'm a bit disappointed that not much has happened in the market. And that being said, we are, as an enforcement agency, a bit slow. We're behind the curve. So things happen in the market first, things go wrong, and then we come in. And that is typically the role of an enforcement agency. While on the other hand, a regulator, a body that can set rules, is more able to prevent harm by setting rules. But there, I would like to echo Noah's comment that regulators or legislators shouldn't be too confident that they are able to prevent all misery and harm before it actually occurs. I'm very much personally also a believer in first looking at what's happening in markets, studying it carefully, and then exactly identify what the harm is and try to solve the harm or prevent further harm by regulation, rather than hypothetically, theoretically fantasizing of what the harm could be and trying to set rules to prevent that theoretical harm. But ultimately, again, this is not my job, but that is in my jurisdiction, the job of the legislator. We didn't sit still since 2018 because we believe the blockchain is a development that we need to keep a close eye on. So what we invested in since then is the creation of a unit specializing in, I would say, technology. We hired a great number of data scientists, which was a first for our agency, which traditionally consists of lawyers and economists. And with the help of the group of data scientists, we were also able to better understand how algorithmic collusion works. How you can we made our own algorithms and see how these algorithms could collude without human intervention, so that we would be able to better understand and analyze if this would occur in real life. But so far, we haven't come across between actual algorithmic collusion in the marketplace. But like Noah mentioned, this is the area, probably the area of biggest concern to us, that will happen, and also because it is so incredibly difficult to detect. So in short, the perspective from an enforcement agency is not as, we are behind the curve. We are a little bit behind the development. I don't think that is bad. I think it's good to let market forces and let markets develop first freely, and then see whether there is a need for intervention into that market rather the other way around. Thank you, Thibault.
Well, thank you very much. Again, we come back to this idea of when do we intervene if necessary, and I think a struggle we're going to discuss now is that if you try to intervene against a smart contract, which is put on top of an immutable blockchain, then it might be too late, right? And yet, if you intervene before the smart contract is being put on the blockchain, then you enter the movie Minority Report. And if you've seen the movie, you know it doesn't end well. So this is the struggle. I'm pleased now that we can move on to part two of our discussion. I've organized questions for you all in two different sub-themes. The first relates to the approach you've been taking in the space. And then I want to ask you about some very specific concrete actions that we can undertake. After this, I will be asking the questions that we have received. Again, feel free to put those questions in the Q&A. And I will start with you, Noah, actually. You mentioned, I think you mentioned, but if not, here's the information that the FTC created a blockchain working group in 2018. You've mentioned that you've been active when it comes to blockchain and consumer protection and trying to identify scams and Ponzi schemes, etc., but less so when it comes to antitrust and blockchain. But what we see in the US is that there are private cases. Just to cite one case, which is currently ongoing, it's a case against the core developers of Tether, a cryptocurrency. And they argued that the currency was a stablecoin when in fact it wasn't. And the CFTC in the United States already sanctioned them for about $40 million for lying about the fact. But it created a bubble, and the bubble eventually exploded. And they are now being sued for 3 times the amount of the potential damage that they caused on the market, which is $1.4 trillion. And so my question to you is the following. Is the FTC following those cases in the private sphere? And what do you think could trigger action on the part of the FTC?
Thanks, Thibault, for the question. So let me give a little bit of context because I think it will be helpful. 2 points. So first of all, you alluded earlier to the working group and the work that we've done that is blockchain, but specifically crypto related on consumer protection. Yeah. Whenever there is a trend, whether it be a fad or what have you, anything that is interesting will draw scam artists. So that is like a thing about human nature. And so we've seen a number of those cases. On the antitrust side, it's important also for the public to understand the law that operates in the US to deter conduct that is illegal is not just the government. Right? The statutes also permit the private lawsuits that Thibault was talking about. And not only do they permit them, they allow treble damages. You get 3 times your damages if you win as a plaintiff. And so we have a very robust system of private lawsuits in the United States that target conduct that allegedly violates the antitrust laws. The FTC and the Department of Justice together couldn't begin to intervene in a small proportion of all the private cases. There are oodles of cases every year that are filed. I think where we like to focus in general are sort of 2 things. One is issues where you see a lot of harm being caused. Right, you see results, and I take your point that once the smart contract is doing the bad work, we may be a little late to the game, but you have to think about specific contexts, and you want to look to see whether there's some indication that harm either is happening or really is going to happen. And the second, of course, is we look to issues that are going to have a big impact, and maybe these cases rise to that level. But I will tell you, as I sit as an FTC commissioner, I can't speak about specifics. Every day I hear lots of complaints. Maybe not every day, but certainly every week I hear lots of complaints from folks concerned that something going on in the market is negatively impacting them. Those can be consumer groups, it can be other competitors or people vertically related to whatever the conduct somewhere in the supply chain. And blockchain issues are not yet rising to that level. I think we need to continue to understand the technology. I think we need to be mindful, but certainly if you had to sort of chart out and graph the list of complaints that I've heard over my tenure, stuff going on in the blockchain isn't high. And I will say the following, while there is a lot that may be opaque, people who are affected negatively notice how they're being affected negatively. And we talked before about the difficulty that government may have with anonymity and so forth. One thing that always works with enforcement is something that Makan strengthened at DOJ, which is leniency. We ask members of cartels to snitch on each other. And when they're facing criminal conduct, they often do. But also the people who are harmed are often very well aware of how they're being harmed. And we just haven't gotten to a place where blockchain implemented harms are being vocalized to us on a regular basis. I may not be seeing it personally. It's possible we're getting other reports, but I think what we're still seeing is the rollout of the technology and thinking about how we might see these harms in the future.
Well, yes, thank you very much. And that's actually a question I want to ask you, because we see a decrease in the amount of leniency applications, but there's a question for later. I know that unfortunately Frédéric has to leave us in about 10 minutes. So Frédéric, here's the question to you. And you know, building on this idea that Noah just mentioned, that blockchain is not, you know, something which does not exist or exist in the cloud somewhere. It has a real impact in the real space. And so for regulators, it might be that when intervening, we may want also to see what's the impact it may cause all over the world in the real space, right, and impacts people in a way which we should be mindful about. And so here's my question. Let us imagine a case in which the agency will intervene against a blockchain, let's say Bitcoin or Ethereum, and suppose the agency wants to impose specific remedies, such as you have to give power to the core developers so they can stop transactions and revert those transactions because this is what we need to enforce the law. This is something that we're going to see eventually, right? This type of cases and the need for those remedies. It seems to me that it could lead to two different outcomes. Outcome number one, this is ineffective because it's hard to force decentralized communities to implement technical changes, right? This is a bit of what we see in China. They say you can't actually engage in Bitcoin transaction, and yet we see that there are lots of electricity going to this kind of transaction. So that's outcome one. Outcome number two, if effective, then what you do is that you impact the blockchain throughout the world because there is no clear pilot in the cockpit. So no one can say, okay, I'm going to do a Bitcoin version for Europe, a Bitcoin version for the United States, etc. So it seems to me that there is a great danger when intervening in the space, and yet it might be necessary. And so my question is the following. What do you think is the role of the OECD in trying to shape not only regulation, but also the intervention of competition agencies to try to uniformize and not to create a race to the bottom? You're on mute, I think. Yes.
Thank you very much for your question. Before I answer it, I want to come back for 1 second to what Noah said about the fact that, and what has been said, the fact that there hasn't been all that much happening in antitrust enforcement yet. And to explain why it is that we at the Competition Committee of OECD decided to be interested in blockchain. And that has very much to do with the fact that the institution of OECD in itself. As you know, the OECD is not only intergovernmental, but it is also dealing with all aspects of economic policy. And the OECD got very interested, other divisions got very interested in blockchains from different angles. For example, the contribution of blockchain to protection of investment, or the traceability, or the governance of firms. And therefore, they approached us. We were working on the digital sector because it does raise a number of issues for antitrust. And it was a natural thing to participate in this joint effort. So I think that the blockchain issues may have been maybe more developed in other areas of economic policy than antitrust at this point. Now, coming back to your question, I think that your question is relevant, in fact, to a much wider set of issues in the digital sector than the particular case of blockchain, because what you're raising is the fact that, or what one can easily see is that there are now in the world 20 or 30 simultaneous proceedings against firms like Google and Facebook in national jurisdiction throughout the world. And those proceedings are largely on exactly the same issues, which are global issues or global practices of those firms. And there is a question there about the effectiveness of antitrust in that case, and how one solved the cooperation problem that you were alluded to. So it's very clear that cooperation or collaboration at the international level is important in many or nearly all of the digital sector issues, including blockchains, but not limited to blockchains. And this is a major theme of work, of course, at OECD. And we contribute to this in two ways. On the one hand, the committee allows the authorities to share their experience and to softly converge and hear from leading experts about emerging issues. So deeper cooperation begins with a common understanding of the phenomena. And this is what we do, so that there can be some consistency, at least, between the direction in which various competition authorities are going to go. And on the other hand, we are also in coordination with the International Competition Network, with the ICN, to deepen international enforcement cooperation among authorities. And there are a range of models that have been identified, ranging from information sharing gateways, joint investigation, the identification of lead agencies, etc. And the committee is exploring those models because it's fairly clear that the traditional exchange of information as we have known it in the past is not quite sufficient to promote the kind of convergence and cooperation between competition authority, which is necessary to face the challenge of global issues which are raised in all countries simultaneously. So we are working on this. Now, in your specific question on blockchains, I would take a step back and think about what kind of competition issue we would like to address with a remedy. And I think there that the creation of sandboxes is an excellent way to try to understand how the new technologies interact with regulation and to identify both problematic conduct as well as unnecessary regulatory barriers. And since a number of those concerns seem to arise with respect to permission blockchains, which serve as some sort of essential facility, one could expect a good part of the remedies would focus on interoperability and access conditions. And maybe this is the first order if we have, we think about regulatory sandboxes. Now, the OECD has done quite a bit of work on the use of regulatory sandboxes to promote pro-competitive framework with an emphasis on the financial sector. And I believe that this model holds a great deal of problem for blockchain. Now, at the same time, I want to say that regulatory sandbox is not necessarily the only possibility. There are others, the test and learn approach to try out new ideas under ad hoc circumstances in a live environment, or the wait and see strategy that allows for informal monitoring of new trends before any formal intervention is performed. So there are advantages, and sandboxes are more structured, they are objective driven, they are publicized, but they're also more costly and more formalistic and resource intensive. But I think that this is, it's hard to jump into an answer to your direct question, and that an intermediate period of something which is one of those techniques to try to sort out what the issues are and what are the possibility of consistent solutions is necessary before we can apply with great confidence the antitrust instrument.
Well, yes, thanks very much. You've actually answered all the questions I wanted to ask you. And, you know, it's funny because the more I do research in the space, the more I see that, of course, it has to be scientific and we need to approach the way with a cool head. But also, as you just mentioned, it's very unclear as to what are the best solutions. And so it is art as much as science in a sense, right? You need to reach such a difficult balance that it might be that regulatory sandboxes are needed in the space. They are known when it comes to antitrust. When you talk with financial enforcers, they actually say that they struggle to get companies to join those sandboxes, but yet maybe this is the best solution. So yes, Frédéric, thank you very much. I know you have to go. I'll see you very soon, maybe in New York. And okay. In the meantime, thanks. I will go to you now, Makan, because I'm very curious about something that you haven't been discussing a lot, at least not in public or to the best of my knowledge. The fact that when you were at the DOJ Antitrust Division and leading the team there, you opened the program for your employees to study AI and blockchain from a technical point of view, and you sent them to the MIT. I believe that this was not mandatory, that this was, on a voluntary basis, and that the percentage of employees that decided to actually go to the MIT to learn was quite high. And so my question is, why did you do that, and why did you feel that learning on the go, as we've been doing in the past when it comes to technology, was not enough when it comes to AI and blockchain especially?
Well, thanks. It's one of the things I realized is that antitrust very much benefited, and the legal system benefited from a background and an appreciation, just an awareness of economic thinking. Of course, there's many economists in the field of antitrust. You can't really do a market definition analysis and a merger or the competitive effects without economics understandings and econometrics analysis. And I thought as the law and the economy is moving, it was really critical to have a basic understanding. I mean, my intention was not to turn our antitrust lawyers and economists into, crypto miners and programmers, but it was to have a basic understanding, to know what questions to ask. And I thought three really key emerging technologies that all have business utilization and application, but critically have real impact on competitive analysis were artificial intelligence, which is really a subset of machine learning, and blockchain. And machine learning and blockchain in different ways impact competition. They create great, if we've discussed today, the great efficiencies that blockchain provides. And I thought it was really critical for antitrust enforcers, at least at my division, to understand how these technologies work, how they impact competition, and what the existing companies that we oversee, whether it's a particular merger or the conduct, what are they doing to implement it? I didn't think we could, fall behind and learn too late that entrenched monopolists that could be disrupted by these technologies have now crushed those technologies rather than it being able to displace them and challenging, the competitive paradigm, particularly as in digital, where the network effects of the technology and the interconnectivity becomes such an important source of market power in and of itself. We need to know that ahead of time. By the same token, to understand that there might be great efficiencies, that you might have mergers in certain areas where you have a combination of certain kind of data, which allows for machine learning that could provide some efficiencies that could be argued, as a potential motivation for a transaction rather than anti-competitive harm. And then finally, the fact that the blockchain itself could be used. You have a public distributed ledger, and you're taking some sensitive information and turning it into public information. And are there competitors that might join a certain kind of blockchain and exchange sensitive information and have price effects? And we need to be much more, and you can do this without actually having a real agreement. So our cartel discipline would not necessarily touch, but it certainly would have a competitive effect, whether in a coordinated function or otherwise. And I thought it was really important for enforcers to know that. And it was voluntary. And I'd say, by the time I left, there were about 20% of the division's professionals that had taken it, and the government paid for that. And we were able to put that together. It was done through an online program. I think it was an 8-week program, and they received a certificate at the end. And my hope is that everybody at the division takes some sort of that, or reads your book, or reads my colleague at University of Pennsylvania, Kevin Warbach's book, or Crypto Dads by Chris John Carlo's book. Those are some fantastic self-help that people can do.
Yeah, thank you very much. I didn't know that. So the main motivation for you was to actually try to understand the text, so to preserve the potential of it. And that brings you back to me, Tina. And I just want to make it clear that when I mentioned law and plus technology, my idea was not to say that we should just, have the benefits of tech in mind, but to consider those so that when we address the issues, we, if possible, maintain those benefits. And this leads me to a very specific question for you as to, because I know that you've been also working quite a lot in the field of AI and the law. And if you're not from Europe, you may not be familiar with that, but we do have an AI Act that is coming. And that act is actually focusing on industries or fields to which you can apply AI. And it's more or less neutral as to the type of AI technology that is being implemented. And my question is, do you think we should take such an approach when it comes to blockchain, which is for regulators to say, well, I think that we should tackle pharma or supply chains or education and blockchain because this is where I see the greater dangers? Or do you think that we should actually focus on the types of blockchain applications, such as self-sovereign identity or cryptocurrencies or NFTs and Web 3.0? What do you think is the right approach here for regulators?
Yeah, I am unmuted. Okay, good. Thanks, Thibault. That is really an interesting question. And well, to be honest, I think we should do both. So if there is an area where the risks are high, as again, the conflict mineral regulation or pharma, as you mentioned, then maybe we should have sector-specific regulation. Another example is indeed self-sovereign identity, which can be seen as a way to implement the ideals underlying the GDPR, maybe. So I think regulation should recognize and embrace the opportunities that a technology offers, and also support such use. And especially for self-sovereign identity, I think supportive legislation is very much required. And I think that is also being worked on in the review of the EIDAS regulation. And also, yeah, the dangers in certain industries, as you mentioned, pharma, but also financial services, they may require scrutiny by the authorities and possibly specific regulation, as for example, the proposed markets in crypto assets regulation. So yeah, both we need all of it. But indeed, based on an understanding of the technology and the challenges of the technology and the possibilities of the technology. And I also very much agree with your approach that law should, when regulating, try to preserve as much as possible the benefits that this technology can bring. And that applies to, of course, both to AI and to blockchain and to any technology.
Yeah, that's again a question I want to ask Noah, because something we've been mentioning is the fact that blockchain is public, and so it would make the market more fluid. And on the other end, it may be helpful to create collusions. And so my question is indeed to you, Noah, as to what I think we see a double effects with blockchain, a visibility effect, right? So you can see what's out there. You could scan blockchain. If I can just show you my screen right now, you will see that indeed some information is available on the blockchain. So here, if I just scan the Ethereum, I can click on the transaction and I can see that, yes, there is a transaction for a price of $125 US dollars. But at the same time, you have some opacity because what you see is that the money came from this account, went to this account. That's the identification of the transaction. And that's pretty much all you know. And so this might be that for antitrust agencies, the idea that we could just scan the blockchains to detect infringement, I think is potentially a no-go, because how do we know if behind this transaction there is, the finance of terrorism or something illegal? And so if it means that indeed we cannot scan the blockchains, and that on the other end, we see that the amount of leniency applications and complaints is declining, including in the United States and in Europe for the last 10 years, it seems to me that something that you mentioned could be the only solution, which is to start from the real place. Because as you mentioned, you may use a blockchain, AI, all you want, quantum computers. If it works and the practice is illegal, it will create an effect that you could see in supermarket and supply chains, etc. So my question to you is the following, Noah. Do you agree with me that agencies have no choice but to be more proactive? And do you feel that the FTC is sufficiently prepared to take action And do you have what it takes? Do you have the expertise? Do you have the budgets? What's your feeling about that?
So I'll start with the easiest part of the question, which is the last one. My view is that we could do with better expertise and a little bit more budget. I don't think we're at the point where we need like a blockchain division, because again, I think we're still working on market developments. With respect to proactivity, I don't think I would agree the way you phrased the question, which is that the agencies have no choice, because I do think that there are ways that we have worked for a long time and that we could continue to work, which could be applied to blockchain, right? We, as I mentioned before, we hear complaints or people snitch on fellow colluders, this sort of thing. It's not that there are no options, but I do agree that there are certain kind of proactive activities that we may want to consider, and others on which, where I'd like to see the learning involved. So the proactive activities are just opening the door, right? If there are things that you are seeing, smart contracts that you're signing up for that look like they could more effectively police cheating, right, in a cartel, that's interesting to know, right? Just as you would look at or think about the implementation of AIs to play games where tacit collusion was facilitated, so too you can think about that here. So the first kind of proactivity is just making sure that the door is open and we're soliciting. And the second is what Makan was talking about, right? Making sure that enforcers have access to the kind of education to understand the technologies we're looking at, I think is critical. The next level of proactivity is an area where I think we need to be interested, but a little bit more careful, because it gets into the chilling innovation or skewing markets in ways that we may not want. So you could theorize at least an idea of requiring smart contracts that cut against collusive behavior, right? That's the sort of thing that jumps to mind. But how you design those and what effect they would have on blockchains that are operating, I think are questions that are the answers to which are to be determined. And I don't think we're quite there yet. So I guess my answer fundamentally is it depends on what we mean by proactive. Absolutely, we should be proactive. No, we should not give up on the reactive ways that how we respond to things in general. But I think as we get into regulators determining how the technology should look without a clear story of harm or understanding how the markets function, there I think we need to be more careful and have better understanding.
Yes, thanks very much. And Martijn, it actually leads me to a question for you. As you mentioned, you've been creating a team of technical experts, including data and computer scientists at the ACM, the Dutch Competition Agency. I'm curious as to why you have decided to create a team, and the growth of it is actually something quite spectacular. So what's the logic behind it? And in February 2022, are you comfortable that if you had to deal with a practice implying blockchain, that you have the expertise that it takes right now, or are you still in the process of creating the team so that eventually you will be able to be in a better position?
Good. Thanks, Thibault, for the question. I think we are learning by doing, and that so that in the sense that, are we already fully prepared? Are we the fireman ready and will go out when the fire is there and extinguish it as soon as possible? Probably not, because it's like how that works with enforcement activities. The first case is the most difficult one, and it will take time and it will require experience. So I'm sure that we over time will be better prepared, and I think that is the tragic of being an enforcer. Second, why did we build up this technology unit? Very much also focused on big data analysis, echoes a little bit Noah's point, is that indeed we are faced on the one hand with a decline in leniency applications, although it's picking up lately again. We still see a steady amount of complaints from mostly customers, that detect certain anti-competitive behavior in the market. We also have informants, people who walk around and talk to people and come up with very useful tips on possible anti-competitive behavior. But we also see a future where we do more in big data analysis and review market outcomes that can only be explained by anti-competitive behavior. So we basically reverse engineer an anti-competition case, which traditionally starts with focusing on the behavior and then look whether that behavior had a certain outcome. And now what we're trying to do more and more is see if we can detect the behavior and then reconstruct and find through the behavior, through the actual market outcome, the cartel-like behavior. And that requires big data analysis, for which we need specialists. Again, with this topic, we are in the learning phase. We are particularly focused now on bid rigging, but we also see other possibilities, particularly in the area of pricing outcomes. We must not forget, though, that competition rules are not only focused on prices, also other market outcomes are important, and those are more difficult to detect. Think about the level of innovation. How can you detect whether there was a practice that can only be explained by an anti-competitive agreement or concerted practice to reduce innovation? But nevertheless, we're the focus on prices and helps us to with the big data analysis helps us to better investigate these market outcomes.
Indeed, and it seems that it's easier, right, to compute prices than to compute the quality of the product and innovation. This actually leads me to ask you a second question. We've been mentioning something here and there during this panel, which is that using smart contracts, you may create a more efficient collusion, because what you end up doing is that you create a quasi-cooperative game. You know exactly how the smart contract will be triggered, you know what's going to be the move of your partner in crime, and it might be good for those colluders. And it seems to me that here what we mostly discuss is how we could use blockchain to impact the real space. But there is something different, which is that you may want to prevent a market player to getting access to your blockchain. So here it's out to in a sense. If I take an example, and I just want to be clear, I'm not aware of any anti-competitive practice in the space, but I know that port authorities are using blockchain quite a lot to automate all transactions. And indeed, it's very convenient, right? You could put a chip on the cargo, and when it arrives, it actually automates a smart contract. So my question is, do you think the ACM will be more interested in this type of practices that directly impacts the real space? And do you see this idea of essential facility being potentially applied to blockchain ecosystems?
Yes, I mean, I wouldn't be able to say we are more interested in the one than the other, but I do recognize that this can be a big threat to competition. It's basically a question of interoperability, and that is as a phenomenon that's high on our enforcement agenda, where we look at instances where lack of interoperability particularly limits innovation in markets. One of the areas that we're looking for at the moment is IT systems for hospitals, for example. And what we see is that there is a huge vendor lock-in by hospitals that are locked in with their IT system suppliers, and that the difficulty of innovative firms to hook on the hospital's IT system for lack of interoperability. And this limits innovation in the healthcare sector, where it is particularly needed in the future.
Yes, well, thank you very much. This leads me to the last question I want to ask before diving into the Q&A. The question is for you, Makan. We've been indeed mentioning interoperability quite a few times. And we know from including the work of Jean Tirole that imposing interoperability is often not a good solution, because you may lock in the market in a technology which is sub-efficient, On the contrary, if it emerges, then this is great. This is what you want, right? And to be clear, as of today, you cannot create a smart contract on top of the Ethereum blockchain and use payment and use Bitcoin as a payment system. It doesn't work. There is no interoperability there. And I think we need to work on that. But so here I want to ask you a question regarding the piece that you wrote for the Wall Street Journal, in which you argue that regulation might be good for crypto regulation, for crypto markets. And indeed, I think we come back to this idea of trying to craft the law in a way that will also, of course, protect consumers, but also enable, a more dynamic ecosystem. And so my question is, how do we do that? Should you still be at the DOJ, or should you want to give any advice to a competition agency? How do we make sure that we avoid passing laws and enforcing antitrust in a way that will destroy or hamper blockchain? Is there a few items that you think should be avoided at all costs or not?
Well, thanks for that. So like Noah, my friend on the panel, I've had the great privilege to have had served in all three branches of the federal government, both the legislative, on the Senate Judiciary Committee, where we both served on the staff. And in the US, we have our three branches that they interact with each other. They're supposed to be usually separate. And of course, NOAA is considered in the executive branch, although they're an independent agency, but our Constitution only allows for three branches. So until we create a fourth branch, NOAA fits into one of those, and they have qualities of all three. But it is the rulemaking in the United States is supposed to be done by Congress, and they establish the rules, and the agencies enforce, or they provide some expertise in the regulatory system. I hope that the future of this technology is not determined either by judicially derived rules that, a lot of very well could happen with respect to the securities aspects and whether or not it is done, because that's not a good way to best preserve the future and its potential. And I do not think, imposing regulations should specifically define a technology. So we should not impose specifics of interoperability. We should let the market decide which one works. However, it is quite critical. You put your finger on an important part of interoperability between Bitcoin and Ethereum. Now let's take it to the next step, the latest buzzword, we've been keep on hearing about the metaverse. Well, of course, there's going to be multiple metaverses. There's not going to be somebody who's going to control the virtual world in every aspect. You might have a Disney metaverse. You might have a Second Life metaverse. You might have, a Call of Duty metaverse. You might have all sorts of different versions of this. And there's going to be commerce that will engage in all of them. Now, if you have earned, a car, or if you've done some work within one system, you want to be able to take your currency, whatever that is, from one metaverse into the other. The only way this ultimately will work, at least in that application of the blockchain, is for you to be able to take that money, go somewhere, or take it to a bank and turn it for fiat currency that now you can use to, buy your clothes, or, buy a great trip to go visit, the Netherlands, for example. But that interoperability is going to be critical. Who should determine that? I would argue it should not be the government. What we should provide is the predictability and the protections that the consumers and investors need. Predictability about the law that will be there should a dispute arise about that. Perfect example is, whether or not a stable coin really is a stable coin and has assets and currencies that back that, or was there deception involved for the consumer and the investor because it was sold as one thing and it was not as secure as it was intended to be. And so those protections need to be there. But I think the market should ultimately decide, and what that means. And parties could come together. You could have, standard setting that allows for interoperability. Of course, it works in the computer chip industry and in wireless communications. Yes, you have disputes and you have fights over intellectual property, but they can decide that rather than the government coming in and imposing that, because long term, that only, I think, hurts the consumer and the competitive dynamics, the Schumpeter type of theories where you have dynamic competition and innovation working hand in hand.
Well, thank you for already, sorry about that, answering one question in the chat about the metaverse. I think interestingly, we see that there is indeed a strong correlation between metaverses and blockchain. Meta announced yesterday that it will be possible to use your NFT as an avatar. Twitter announced that last week. So we're going to see a lot happening in the space. I do want to ask a question to you, Noah, who was asked by Balash Bodo in the chat, as to why do you think that, so he's making the point that for certain technologies, it's actually good to intervene even before it's too late, right? And that we shouldn't wait and then intervene. And it's making the point that it might be the case for nuclear power, for instance. And so the question he's asking is, why do you think that blockchain is not such a high-risk technology that we would need to intervene right now and not wait before it's too late?
Okay, it's a great question. And I think some of the answer is in the example that the questioner gives. So, where do we get nuclear power? Civil energy production of nuclear power comes from a program to develop nuclear weapons, right, which are the most destructive technologies in the history of mankind. So the potential for harm is quite clear. A side note, and this is not my area of expertise, the US established, I don't know when, I think in the 60s or the 70s, the Nuclear Regulatory Commission, and we've not had a new reactor approved since then. And that, by the way, has had environmental and other ramifications. Blockchain, at least where I start, and I think you could quibble with this, but the fundamental dynamic that we're talking about here is one of decentralization. So when I am thinking as a competition enforcer, a competition regulator about the harm I'm addressing, which is not the fraud harm that we see on the securities side, right? It's not investor protection, but the question being competition, fundamentally what the technology does is it decentralizes. And so, as I said before, with respect to things like enabling more tacit collusion or even explicit collusion, there are risks here. But I don't approach the technology from a competitive perspective as immediately presenting nuclear or anything like that kinds of risk. Fundamentally, it seems to be helpful. I think we should look, I think we should understand, but it doesn't arise as an inherently problematic thing. In fact, its architecture is one that suggests that it is helpful in the main rather than hurtful. So that's why I don't start at, let's immediately adopt a precautionary principle and impose rules. I think we need to understand it better. And I certainly would like to see more harm before we stop in and inhibit the innovation or take it in a direction that may itself be anti-competitive.
Well, thanks a lot. Tina, next question is for you. And it also ties to what Noah just said. We need to see harm. And one place where we could see harm is actually within the functioning of ecosystems, such as blockchains. And there is a question in the chat, and this is indeed a matter of concern that I read a lot about in academic paper, which is that if the validators or the miners come together and in mining pools or other forms, you may see a concentration that is so high at that level that you can't argue that the blockchain is decentralized anymore. What is your take on that? Do you think that it should indeed be a worry? And if so, what can we do?
Yeah, I think it's a great question and a very interesting development. And I think that is exactly what we see happening, that, decentralization, so to speak, sparks centralization, because mining has become so difficult and you need pools to be able to do that. Yeah, I think we are just discovering that this is happening and thinking about what to do about it. And again, I mean, this is a an argument to say that we need governance, right? We need to know and find out and design who is in charge of the blockchain and who is responsible and who can take decisions. And I know that you in your book talk about the nucleus, which is, well, in a sense, begging the question, like, who are they and who are they accountable to, and what motivates them? So what are their incentives and how do we need to regulate this? So this is all, I think, very, very interesting and relevant stuff that, yeah, we need to look into. It's more challenges.
Yes, more research for us, which is
more
good news.
research for us, exactly. Yeah.
Indeed. There is indeed, I see Bruno comments and say that poor countries can't offer mining anymore because you do have the electricity costs. And it actually leads me to the very final question to you, Martijn. No pressure, which relates to, and I think this is central, the threat that blockchain may actually create to nation or actually to their power. A very obvious example is the fact that blockchain might be considered as, at least the tokens, as currencies, something to be discussed in the next panel in about 2 minutes. And indeed, we see that there is competition in a sense between blockchains and the nation states. And so do you see that as being a matter of concern? And do you think that competition agencies have a role to play here, or should they just, for now, tackle the economic issues that we've been discussing?
For a final question.
You do have 20 seconds, yes.
Well, I think yes and no. I think competition, I'm a strong believer that competition and enforcers have a lot on their hands, and they have a lot of work already. And so they have to be careful with expanding their reach. I think that this is one part of the answer. The other part of the answer is, and particularly coming from a smaller country, this is definitely something that needs to be dealt with on a at least a regional, if not a global scale. And that's why I think it's important that we as competition authorities in the European Union have a European competition network and a central role for the European Commission to play a role here. So that's why I think it's from a European perspective that if there is a role to play for competition authorities in protecting sovereignty against these developments, that is something that should be dealt with at least at the European level.
All right, well, thank you very much. Again, that's something to be discussed for the second panel, the example of Libra or Diem, because we see that indeed the European Commission may have feared that introducing such currency will disrupt the existing financial institutions, and it may explain why they went after the product, although it was not yet on the market. It is time now for me to thank you very much. It has been a fascinating discussion. I hope everyone agrees in the chat and in watching us. So thank you very much. Of course, discussion to be continued. It is time now to move on to the second panel of the day. This is when you may actually have a 1-minute break, time for me to bring the new panelists on the forefront of your screen. Welcome to the second panel. I'm delighted and incredibly excited to have a discussion about how to regulate blockchain. You've seen that already. We've been discussing this quite a lot during the first panel, and I will try my best to make sure that we also discuss what we've been touching upon in the first panel in this panel, so to show that you can't just act in the space considering one issue at a time. For the purpose of answering this very complex but fascinating question, we do have quite some great panelists, starting with Professor Wright, who is a associate clinical professor of law at Cardozo Law School, I think on leave. Is it still the case? Yes. The author of the book Blockchain and the Law, that was the first, or I mean, at the very, very least, the more visible book out there that you should read if you are interested in those issues. And he's also the CEO of Tribute Labs. which is something that I use when I go around to conferences. I always show a demo of what you do. I do have to mention always that I have no tie with Tribute Labs, but I think it's a great product and service. So let me take the opportunity to say that again. We also welcome Commissioner Peirce, who is a commissioner at the Securities and Exchange Commission in the United States, where she was sworn in on January 11, 2018. We welcome Lukas Repa, who is a senior policy officer at the European Commission DG Connect, where he focuses on blockchain and fintech. We also have with us Judge Pēteris Zilgalvis, who is a judge at the General Court of the European Union, and the former head of Unit for Startups and Innovation in DG Connect at the European Commission. And last but not least, my friend and colleague, Arno R. Lodder, who is a professor of internet governance and regulation at the Wright University, Amsterdam. And I must say, an excellent tennis table player and a fine music listener. So we've been talking about music in the first panel, and I'm sure that Arno will have one or two quotes about music for us today. No pressure, but I expect a few from you. So we will proceed the exact same way we've been proceeding with the first panel. First, each of the panelists has 7 minutes for introduction, and we will then enter into a discussion and open the floor to the Q&A. So again, feel free to enter your questions in the Q&A, and we'll start in the exact order that I just mentioned. So Aaron, the floor is yours.
All right, and I prepared a quick presentation. Thanks so much, Thibault, for pulling together this program. The first panel is amazing. It's an honor to be on the panel with everybody here. So just give me a second just to set everything up.
If the question, if it works, the answer is
Does it work?
Yes.
Okay, great. So, I just wanted to talk briefly just about regulation and blockchains, the reason why there's some challenges with it, and then really just to pose just some areas and questions that I think collectively we're going to need to sort through. So just to level set, and I think this was touched on in the previous panel, blockchains at their core enable the creation of increasingly automated systems that rely on hard to modify software. In the Ethereum ecosystem, that software is referred to as smart contracts. For many lawyers, that's a bit of a misnomer. And there's a bit of oversimplification in the hard to modify software, but just run with it for purposes of this presentation. One way to view smart contracts is that they create rules that can be used to manage the creation of assets, to coordinate groups, and to structure financial and commercial systems, including markets. So they're very powerful in terms of what they can do. And they also attempt to ossify rules and govern behavior, primarily using code as opposed to legislative or bureaucratic systems. And that's pretty interesting. In the book that Thibault mentioned that I co-authored, we referred to this as Lex Cryptographica, kind of drawing on earlier notions of kind of norm-based laws that emerged during the previous generations. I really want to just emphasize that the word is primarily. So even though systems are trying to use these hard to modify rules that are based in code, they also have inherently political dimensions and also operate via social norms. And in many ways, these smart contract rules are just trying to create more structure around some of the norms or behavior that people want to participate in. Today, many smart contract-based systems or even blockchain-based systems aspire to not rely on any one party, but in practice they do. And there's a question as to whether or not these systems can be built to not rely on any party over the long run. Whether that they can achieve those objectives, it's still an open question. But I think at a minimum, when thinking about blockchains or smart contract-based systems, they do thin the need for intermediaries. And this is likely going to require approaching certain regulatory considerations differently, especially in industries or areas where regulations are applied primarily on a large intermediary of some sort. What's, I think, challenging and also needs to be taken into consideration is that these ecosystems are growing fast and the technology is improving such that over time, I think it's reasonable to assume that they will become less dependent on central parties, and that could result in potentially more uncontrollable systems. So when thinking about regulation, I think people need to tread carefully to make sure to hit the right balance, because if it's too restrictive or if it doesn't really meet the market where it's going, I think the end result could be potentially disastrous. Because blockchains oftentimes aspire to be not dependent on any one party, but there are points of centralization, and that means that the technology as a category is susceptible to regulation. There's oftentimes centralized parties built on top of an underlying blockchain or a smart contract-based system. An example here would be a centralized exchange. There's different aggregators that have emerged. People run interfaces or user experiences. There's also centralized parties that kind of sit behind and support these systems, whether it's a blockchain itself, like a validator or miner, or if it's a smart contract-based system, let's say like large participants in automated market-making systems or other, other types of systems that we're seeing emerge. And in my mind, at least, as with other peer-to-peer technology, these points of centralization, even if they're thinner, or central parties that can be identified, can be regulated directly or held responsible through secondary theories of liability. We saw this in the context of copyright litigation in particular, where folks that were operating or supporting peer-to-peer systems that enable the transferring of media or music or other copyrighted works were still found liable for copyright violations through secondary theories of liability. There's also indirect ways to regulate these technologies through taxes, influencing social norms, and even potentially participating directly in crypto markets. Regulatory clarity is increasingly needed. This ecosystem is not going away. It's growing incredibly fast. If we had this panel a couple years ago, we talked primarily about digital assets. What we're seeing is kind of an explosion of three concurrent curves. One that we saw primarily about a year and a half ago involved decentralized finance, or kind of more advanced smart contract-based systems that are trying to replicate or improve certain financial systems. We're also seeing the explosion of NFTs, which are being used in the context of supporting artists, musicians, digital fashion designers. We're seeing a number of large companies also exploring the use of NFTs to connect with their consumers, customers, et cetera. And I think what we're also going to see over the next couple of years is an increasing number of people coordinating their activity through DAOs or decentralized autonomous organizations. So I do think that crypto and blockchain technology has kind of crossed a bit of a chasm and is really poised to grow. And regulatory clarity is going to matter here. There is an argument, and people can push back on it, that Web3 and blockchain technology could be larger than the first two waves of the internet combined, since it closely couples a financial element, and because it's aiming or aspiring in part to break apart some of the larger internet companies that we saw through the first two waves. And regulations will shape where the technology is developed, where wealth is created by this technology, and if not appropriately calibrated, the degree to which these systems achieve more of an uncontrollable endpoint. So these issues, I really do think, will have a profound impact on what the world looks like, in 10 years or 20 years. And there's a number of very, very hard regulatory questions, and I don't think anybody has the full answers to these questions. So some that I just wanted to flag, and hopefully we can discuss in the panel, include things like the degree to which creating smart contract-based systems create potential liability. Will you be liable, and the degree to your liability if you create them? Does this answer change if the system is inherently illegal? Does this answer change if the system has some legal purposes? These are similar questions that we saw with contributory liability for copyright infringement litigation, and those questions went all the way up to the Supreme Court. The degree to which somebody that implements these systems could be potentially liable for doing that. So even if you develop it, and maybe that's found not to be illegal, if you implement it, maybe that creates some sort of liability. The degree to which validating transactions for these systems create potential liability. These are similar questions to what we had to grapple with ISPs and other pipes that support the internet, and whether there should be some safe harbor protections that are provided to developers or validators or the creators of digital assets in order to push regulation more to the edges. That's the approach, at least in the US, we took when it came to the first several waves of the internet. There's lots of hard questions about digital assets that are created on a blockchain. Questions like whether a token that's not marketed as an investment is a security if it only provides governance rights or has some sort of utility and is not directly sold to the public. Does this answer change if users can earn those types of tokens if they interact with the systems or participate in governance? Does this answer change if it's tied to a not-for-profit entity and expressly does not promise, imply, or provide a distribution of profits? And does this answer change if users of the platform are led to expect a token in some sort of way, either directly by the folks that are creating it or indirectly in some sort of manner? In the NFT ecosystem, we're seeing hard questions about whether or not fractionalized shards or pixels of an NFT can be considered a security, whether a token is a security if it provides a holder with future rights to participate in an event, either real or virtual, and whether the answer to that above question changes if the recipient of a token was unaware of this fact when it was acquired or purchased. When it comes to DAOs, we have deep questions about the nature, the interests of the DAOs, and whether those will be considered security, particularly if they resemble more like member-managed partnerships. We've seen the SEC weigh in on this through a 21A report in the past, but if a DAO doesn't have a controlling interest, does that change the analysis? If these interests are securities, then there's even harder questions about how these organizations can interact with public markets. Depending on the jurisdiction, a little less of a concern in the US, the enforceability of smart contracts, whether it's possible to have an entity without a manager. And then there's also a host of other questions related to tax. Should tax rules be updated given the velocity of transactions? Should there be de minimis exceptions? There's custody considerations that are looming on the horizon, especially as we see more and more decentralized and smart contract-based custody solutions emerging. And then there's two more. One is just related to AML KYC requirements. Can they be enforced and interact with these systems? Who has the reporting obligations? Whether these laws should be updated to enable the portability of these credentials, which I think would be a huge advantage for folks that advocate for these laws to be applied to these systems. And should intermediaries be required to collect information about unhosted wallets or wallets that are not funded in centralized exchanges? And then the last, and these are very tricky questions, is just about privacy. Blockchains are very public. The last panel talked quite a bit about that. The public nature of blockchains is great in many ways, but it's also, has certain downsides. And so many users want to preserve some privacy about the transactions that they're engaged with. They don't want their entire bank account or all their assets to be publicly discernible. And so many of them are legitimately moving to privacy preserving technology to prevent that. Obviously, privacy preserving technology also comes with downsides and can open up avenues for bad activity. So we really need to figure out what degree of privacy preserving technology should be permitted and how that interacts with traditional financial institutions, and also the liability of the developers that are creating these systems and participants in these systems. And we have some answers, at least in the US, to the second question, but I don't think that we put enough time into thinking about the degree to which privacy should be preserved in these systems without creating regulatory guardrails. So lots of hard questions when it comes to blockchain plus regulation, and hopefully that can add some insight into the conversation today. Thanks so much for the time.
Thanks a lot, Aaron. And of course, be sure that we will provide an answer to all of those questions individually.
We'll figure it all out.
Exactly, in about the next 2 hours. And starting with Commissioner Peirce, the floor is yours for your introduction.
Thanks, Thibault. It's Aaron's presentation is very hard act to follow. I'm glad that he's thinking about these issues, and glad you're thinking about these issues as well. Congratulations on your new book, which I haven't had a chance to read, but was able to watch some of the videos. I'm sad that we can't be there in Amsterdam in person. Typically a trip to Amsterdam means that I get to come home with lots of great food, including, of course, most importantly, a big wheel of cheese. So I'm sad that this has to be virtual. Before I begin, I must note that the views that I represent are my own and not necessarily those of the commissioner or my fellow commissioners. So I'm just going to provide some background on the SEC first, since that's my agency, and then talk a little bit about where regulation stands in the United States. And there's a lot of ambiguity, frankly, around where it stands. So I don't know how satisfying this will be in terms of giving you concrete a concrete idea of what regulation might look like in the long term around blockchain. So the SEC is an independent agency. It's made up of 5 commissioners. I'm one of the commissioners, but I'm not the chair. The chair sets the agenda. The commission is politically balanced, and that ensures that there's a wide variety of perspectives being brought to issues. I think that's particularly going to be important around regulating blockchain, as we see there are a lot of different things that need to be balanced as we approach blockchain regulation. The commission is a regulatory body first and foremost, so we write rules and then we examine for compliance with those rules, and ultimately we enforce the rules. We're a relatively small agency as agencies go in the United States. We've got about 4,500 staff. And we have a very limited but important mission. It's protecting investors, facilitating capital formation, and ensuring fair, orderly, and efficient markets. And we are one of 2 capital markets regulators at the federal level. And the other is our sister agency, the Commodity Futures Trading Commission, which also has a role to play in regulating crypto. One complicating factor is that the United States does have a very fragmented regulatory system. So any new entrant trying to offer a financial product or service in the United States is daunted by the fact that you've got to deal not only with potentially multiple federal regulators, but also with state regulators. And so it can be quite difficult for someone who comes from outside of the traditional world to come in and do something new in the financial space. I think that's a real problem. It means that innovators often avoid the financial markets because it's just so complicated. Certainly the tremendous growth of crypto and the retail participation in crypto has drawn the attention of the SEC and the CFTC. Our current chair, Gary Gensler, comes to the issue with a lot of knowledge. He was teaching about blockchain at MIT immediately before coming to the SEC as chairman. So there was a lot of anticipation around his arrival and around what potentially that might mean for regulation of crypto. As with any new chair, he has a lot of items on his agenda, and crypto is just one of those items, and perhaps not the top priority. So I think it's moved a little more slowly than some might have expected. Congress in the last year or so has gotten a lot more interested in crypto. There has been attention, some of it positive, some of it negative on crypto. But I think you're seeing more and more that individual members of Congress are putting forth bills, draft legislation essentially to deal with various pieces of crypto regulation, and we'll see whether that moves forward. Legislation is always very slow to move in the United States, but there certainly is some competition among the different regulatory bodies trying to figure out who has jurisdiction, and so perhaps Congress will want to enter the fray to make the determination of who should regulate what. For the SEC, the threshold question is whether particular digital assets are securities. If it is a security, if a digital asset is a security, then the SEC has jurisdiction over it. Chair Gensler has been pretty upfront that he thinks that most digital assets are securities, and in that he's similar to the last chairman. Chairman Clayton also took that position that at least initial coin offerings were securities offerings, and so taking a broad view of what is a security means that we at the SEC are claiming jurisdiction over a lot of the industry. And so we've done that by relying on the very broad definition of security in our federal securities laws, and the decades of cases around interpreting those provisions in the securities laws have led us to bring quite a few actions in this space, although probably the number of actions pales to in comparison to the activity out there, but we've still been quite an active regulator in this space. Aaron mentioned one of those cases. That was the 2017 case, the Dow report. It was actually sort of our message, our first message to the crypto world that we were looking at initial coin offerings and seeing them as securities offerings. I've typically not supported enforcement cases for pure violations of our registration provisions under the securities laws, absent indicia of fraud. One of my reasons for opposing these cases is that I think we are making a mistake by taking this enforcement first approach. I would like us to instead put our regulatory foot first, as we are, as I mentioned at the beginning, we're a regulatory agency first and foremost, and I think our best way to go about regulating this space is to set out some clear rules, tell the world where we think the securities laws are implicated, and then make adjustments as needed to allow the technology to develop as it will benefit society, instead of trying to develop in a way that conforms to securities laws that have worthy objectives, but perhaps the mechanism for achieving those objectives, perhaps we can be more flexible around the mechanism. I proposed a regulatory safe harbor for token distribution events, and that's something that I'm hoping that my colleagues will want to engage on. So far, haven't gotten a lot of uptake on that, but the idea is, can we ensure that purchasers of tokens get the information they need, but also do so in a way that doesn't saddle these networks with the full panoply of securities laws. So another issue is the application of our market structure rules to crypto. And I think during 2022, this is going to be a big issue. Chair Gensler has made it very clear, as I noted, that he sees most digital assets as being securities. And given that, any platform that trades one of those digital assets is required to register with us as an exchange or sort of an exchange light, an alternative trading system. Now, he said to these platforms, come in and register with us, but there are a lot of questions that need to be answered about what that would actually look like before it could happen. So I suspect that we'll see a lot of conversation around that this year. And Aaron mentioned DeFi and some of the challenges around DeFi regulation. I think that's really an area where we will be challenged as regulators who are used to dealing with centralized intermediaries. And our tendency, I think, is to find someone that we can slap the label of centralized intermediary on, even if there really isn't one, because we want to be able to hold someone responsible. So that's certainly an area to watch, and one I have some concerns about. Those concerns were heightened by a regulatory proposal that we issued last week, which actually purportedly was only about government ATSs, government. These are the alternative trading systems I just mentioned. But in reality, it proposes to redefine exchange in a way that's quite broad. And I think it's something that people in the crypto space, as well as people in the traditional security space, really need to study to understand what the potential implications are. So I'm looking forward to hearing from commenters on that. Another big regulatory issue in the United States is whether or not a Bitcoin exchange-traded product, a spot-based product, can trade in our markets. So far, the answer has been no over my objections in many of those instances. And so I think it's that those rejections, I think, are sort of emblematic of the way we tend to look at crypto in the United States, at least at the SEC, which is with a really skeptical eye. And that attitude, I think, has really harmed us because it hasn't enabled us to engage with the industry in a productive way to answer that question of how can we achieve the objectives of the securities laws in a way that makes sense in this space. And I think it is possible for us to do that, but I think it's not possible for us to do that on our own. And so we've consistently told people they can come in and work with us, but the results have not really been very reassuring for people. So I'm very concerned that we're not taking a productive approach in this space. But there's always chance for us to change. So I remain hopeful that we'll change and embrace a more productive approach. We do certainly work with other regulators. We're all facing the same challenges. So not only do we work with our domestic counterparts, but we work through international organizations, and crypto has become an increasingly frequent part of the agendas of organizations like the Financial Stability Board, the International Organization of Securities Commissions, and the Global Financial Innovation Network. I'll leave it there, but I'm looking forward to hearing from the other panelists and to being part of the conversation.
Yes, thank you very much. A lot to unpack already. And you've been mentioning partnering with other regulators, and I see that Lukas already has unmuted himself. And indeed, this is your turn. Sorry about the hurdle for you to join us, but please, the floor is yours.
Thank you so much for having me. It's a pleasure to be there. I should like to join Hester and Aaron in congratulating you on the book, and indeed on regrets to not being in Amsterdam physically. It would have been a pleasure to be around the table and to discuss also having our panelists next to one another. So I think I should start a little bit by putting things into perspective as Hester Peirce has done for the United States of America. I'll try to a little bit describe the situation in Europe. So as you know, the European Union consists of 27 member states. So Hester Peirce's reference to the difficulties of divergences between state regulators and federal regulators are all too familiar to us. We do have, of course, our divergences between the national legislations. And that is one of the similarities between the United States of America and Europe. The European Commission, where I work, is, so to say, the executive branch of the European bodies. It is tasked with enforcing the law, but also with making proposals for new European laws. And perhaps I can briefly describe our approach to how we make these proposals, in particular in the area of crypto assets. So if you would ask me whether we have a pan-European law on blockchain, or whether we have the appetite to adopt a pan-European law, an all-compassing law on blockchain, the answer clearly is no. This is not what would be meaningful. Blockchain as a technology is cross-cutting. It's cross-cutting. It can be used in the financial services sector, and we have heard Aaron and Hester speak about crypto assets in particular. We could also talk about distributed ledger technologies in capital markets for trading and post-trading. But blockchain as a generic technology can be used beyond that. And in Europe, we are particularly also interested in using blockchain in sectors such as mobility, energy, manufacturing, for supporting Industry 4.0 and so forth. So our regulatory and legislative agenda spends a little bit beyond the focus on the regulation of crypto assets, which is obviously necessarily in the focus of a securities regulator. Our approach to regulation is the innovation principle. We want to regulate where it's necessary. We don't want to regulate where it would create harm to innovation. So our proposals for regulation are driven by a desire to balance the need for consumer protection on the one hand with the need to create an innovation-friendly and conducive environment for our industry. And this brings us to the principle of technology neutrality. I think the same activities in Europe that create similar risks should be treated similarly, whether actors use a blockchain, whether they use a DAO, whether they use a DeFi, or whether they use a traditional limited company to issue a security. The risks are the same, and therefore, in principle, also the consequences should be the same. And we had a lot of sympathy for the general approach of the SEC back in 2018 when they issued the first guidance for the DAO, saying that, well, if you use a DAO for issuing a security, whether it's a DAO or a limited company, if you issue a security, we treat you as the issuer of a security. I think that's a very sensible approach in principle, and a lot of enforcement agencies in Europe have followed that approach to look through the shell and to look behind what is really put on the market. But we have also tried to support the industry, because a lot of startups have come to us and said, look, we would like to comply with the law. We would like to conduct initial coin offerings in compliance with the law. The problem is that if you issue my token in Germany today, it qualifies probably not as a security, but then a buyer in France would probably go to the French regulator, and the French regulator would say that is a security, and the other way around. So faced with this fragmentation of the interpretation of the current legislation, we had to put forward a comprehensive legal proposal for a regulatory framework for crypto assets. And this is the markets in crypto asset regulation that is now in the process of being discussed and hopefully soon adopted by the co-legislators. As you know, it's now trialogues between Parliament and Council, and we have good hopes that the French presidency might be able to conclude the negotiations on the text of the markets in crypto assets regulation. Just looking at the long list that Aaron has put on the table of problems with cryptocurrencies and blockchain, from civil law to DAOs under company law, fiscal questions, anti-money laundering, privacy preservation, I think it is fair to say that here the competences will naturally be shared between the European Union and the member states. We are not going to solve all those questions. In particular, the fiscal questions of how to treat crypto assets are purely a national competency. And you should not expect soon a law that will tell how crypto assets are to be treated under national fiscal rules. But where we are making efforts to harmonize the approach is obviously for anti-money laundering. There we are cooperating closely with the FATF. We are trying to implement the guidelines of the FATF in the next amendment to the Anti-Money Laundering Directive as faithfully as possible, trying to also square tensions with our general data protection regulation that puts certain limitations on crypto as a service providers in sending personal data abroad. You know that the FATF requires our crypto asset service providers to send a lot of detailed information about the payer to the payee's wallet abroad, but there are, of course, these tensions with the GDPR. So that is something we are working on. And then we are also trying to really boost the use of blockchain technologies outside finance. I'm talking here about digital credentials and electronic identities. So in the area of self-sovereign identity, there's an enormous potential for blockchains to help citizens have a more citizen-centric control over their identity, control over their credentials. So we are going to put forward here proposals and a regulatory framework that creates certainty for trust service providers, what they should look at and what they have to take care of when using distributed ledger technologies for digital credentials, for DLT. So a little bit of an introduction from my side to Europe. I hope it was not too long. And let me add the disclaimer, because I forgot it at the beginning. Of course, like Hester Peirce, I am speaking in my personal capacity, and nothing I say represents an official position of the European Commission.
Well, Lukas, thank you very much, including for all those announcements. I can't wait for the discussion, but I'm also very curious about what the last two speakers on the panel may have to say as an introduction. And so for now, the floor is to you, Judge.
Thank you very much, Thibault. And I think I'm being restrained by cybersecurity, so I'll have to ask you and Kirill, please, to advance my slides when I show them. But like the previous speakers, I will also announce that I am speaking in a personal capacity, my personal opinion. But I'm coming from the General Court of the European Union, which is one of the two courts of the European Court of Justice, which aims to ensure that EU law is interpreted and applied the same in each EU country, ensuring that EU countries and EU institutions abide by European Union law. I'll say a few words about blockchain and EU competition law. Next slide, please. I'll say a few words about blockchain as a tool to enhance competition, also building on some of the work, Thibault, that you and Vitalik Buterin have published, and then blockchain that could be a tool to hinder competition and that might result in enforcement and possibly court cases in the future. Next slide, please. Okay, as Thibault, you have previously said, and I can fully agree, law should not be opposed to technology or more generally to progress. Law should move with the progress of the society and with the progress of science and technology. Therefore, I would say that regulators and judges interpreting regulations should not impede the development of technology. However, the law can support technological progress as far as new technologies are not used in a way that might impinge on fundamental rights, for instance. Next slide, please. Blockchain as a tool to enhance competition. Next slide, please. The scope of competition law is aiming in Articles 101 and Articles 102 of the Treaty on the Functioning of the European Union to prevent collective or unilateral conduct of undertakings limiting competition within the internal market. Next slide, please. Market power, the dominant position which an enterprise undertaking may gain in Article 102, relates to a position of economic strength which enables it to prevent effective competition by affording it the power to behave in an appreciable extent independently of its competitors and its customers. And this comes from Telia Sonora Sverige, a case. Next slide, please. In a dynamic market environment, innovation regularly overthrows the current market order and pushes the limits of the relevant market. This aspect of innovative markets needs to be analyzed with legal certainty in mind, and this is one of the duties of the court. The Court of Justice reviews the general court's, where I am, judgments on points of law. Only where the evidence has been distorted may the court revert to issues of fact. This has made the General Court of the EU the prime addressee for parties challenging the Commission's market definition in Article 256. This is in Ziegler versus Commission. Next slide, please. The object of decentralization, a lot of what we're talking about today. In essence, we have a meeting of the minds or a meeting of aims here. The aim of EU competition law is to prevent centralization or concentration of market power detrimental to competition. Centralization by too few competitors engaged in anti-competitive agreements to fix prices or to coordinate practices is forbidden. And centralization or concentration by a competitor which is dominant in the market is forbidden if it's not resulting purely from competition on the merits. Next slide, please. Blockchain as a tool for decentralization, and here I quote you, Thibault, and Vitalik Buterin, who we all know from Ethereum. Blockchain technology can be seen as a way to achieve decentralization by allowing market players to retain the ability to make decisions without having to follow the instructions of a centralized economic entity and making transactions more cooperative or peer-to-peer. As such, it could enhance competition by avoiding centralized power on a specific market. So this sounds very good, both from the point of view of law, as well as from a dynamic and participative economy. Next slide, please. Blockchain as a tool to hinder competition, as was stated by several in the previous panel and in much of the legal discussion. Blockchain could also be used in order to collude against a free market. Next slide, please. You could foresee that an undertaking could be held liable for infringement of Article 101, where such a firm contributes in full knowledge of the relevant facts to the implementation of a cartel on a market that is separate from that on which the undertaking itself operates. This is coming from Trehond. To be held liable, it should be demonstrated that the undertaking had knowledge of the implementation of a cartel. So this is something, if a cartel or if it was charged that a cartel was being facilitated utilizing blockchain as a facilitator. Next slide, please. Public blockchains. It could be said that an entity dedicated to supporting public blockchains and related technologies may, even though it's not profit-making, be considered an undertaking. The fact, and this is coming from the case that's cited below, Casa de Risparmio di Firenze, the fact that the offer of the goods or service is made without a profit motive does not prevent the entity which carries out those operations on the market from being considered an undertaking. There could be issues with smart contracts, for example, being paid by transaction fees if you had anti-competitive behavior in such a market situation. Next slide, please. Determination of the relevant market. A relevant market is defined according to both the product and geographic factors. A relevant product comprises those which can be seen as interchangeable or substitutable by reasons of product characteristics, prices, and intended use. Next slide, please. Blockchain and concerted practices. A concerted practice is where there's a coordination between undertakings taken to a stage where an agreement has been concluded and where they're substituting this for the risk of competition and having practical cooperation between them in order to avoid the competition. This comes from Durovit, and of course is something that could be a pitfall on blockchain-based cooperation. Next slide, please. Blockchain and exchange of information from the same Durovit case. It's clear from settled case law that the exchange of sensitive information infringes Article 1011, in particular where it underpins another anti-competitive agreement. Next slide, please. Blockchain, as we know, may allow transparency of the transactions between users, may allow, if you're not using privacy enhancing technologies and depending the way that the blockchain and the blockchain application is designed. And then this could give those users the opportunities to adapt their conduct on the market, giving information on prices and conditions of such transactions. Which could be contrary to, again, Article 101. And you see this, for example, in the cases on the manipulation of the Euribor interbank reference rates, exchange of confidential information, and restriction of competition by object in HSB holdings. Next slide, please. And concluding now verbally and saying thank you, that right now, it would be a case-by-case analysis of charges that would be against actors utilizing a blockchain with a anti-competitive aim. And this would be both by the competition authorities, which was stated in the previous session, and eventually by the courts to look at such behavior and to see if it would have an anti-competitive aim. So it's in the interests of blockchain players to design both their applications and cooperation on the blockchain in ways that avoid the pitfalls of contravening competition law, while in the first part of my presentation, utilizing all the opportunities that decentralization offers to have competitive and dynamic markets that not only don't have problems with competition law, but actually make the markets much fairer and much more innovative, hopefully. So thank you for your attention.
Well, Pēteris, thank you very much, especially for creating a bridge between the first panel and the second one. And as you will see in my questions, I will try my best to see when addressing those issues, which here might be related to competition law, but how do you also take the role as the general court, as a regulator almost, or at least as an influencer of the practices. Yes, indeed. But I think it's more than that, and I will give some concrete example of where you might see that court decision may regulate in a sense, although I know this is not the word that I should be using in front of my law students, but I will be coming back to those issues and to see the interplay between regulators and courts. So thank you very much. Arno, I think that you're ready, so the floor is yours. You're on mute. Yeah, you're on
mute will always help to make yourself heard. You can see my slide now?
Yes, it works perfectly well.
Okay, nice. And the next slide is not, it was just, okay, yeah. Okay. So, good afternoon. Welcome, everyone. I'm very glad to be here. Big shout out to Thibault for pulling this all together, and it's an amazing panel I'm proud to be part of. When preparing this presentation, I thought let's dive into the book of Thibault and do it in a modern way, because in some sort of sense I like to stay forever young, and like the current young generation, sort of TikTok people, they watch video. So I watched the video regulating blockchain, and then I wanted to go to the book, but I couldn't find a chapter because it had a different name. It was called Running the Formula. But I think the combination of the two actually expresses what this panel should be about, that when you regulate a blockchain, you should keep on running the formula, because you should combine this technology with the laws. I think it's a very nice coincidence that the chapter and the video has a different title. As it comes to blockchain, I'm sort of seasoned observer. I started like 10 years ago being interested in Bitcoin and the law, but I didn't really understand it. So then I started doing some lectures, some 8 years ago, about Bitcoin. And the reason I did it was that if you read, then you learn something. And if you write about it, you know it. And I thought, well, let's teach about blockchain and Bitcoin so I can master it. But I have to disappoint you, and in particular myself, because I still don't really master the topic of blockchain, although at a sort of conceptual level, I can grasp it. At the same time, also 2014, I saw this in one of my slides from back then, this Canadian lawyer started to take a lead in writing the first Bitcoin law book. And I remember I sent her an email telling her that I would be interested to contribute, but I wasn't asked to do so. I don't know exactly why, it doesn't really matter. But when I was looking earlier this week for this book, I couldn't find it. And the only reference I could find were about news items from 2014. So it might have appeared, I don't know, but I couldn't find reference to the what could have been the first Bitcoin law book back in 2014 or 2015. Fast forward 20 to 2021, so 7 years. This is what I found about the European Commission. We have one representative here on this panel, of course, from the last summer, June, the legal and regulatory framework for blockchain. The European Commission recognizes the importance of legal certainty and a clear regulatory regime in areas pertaining to blockchain-based applications. And when you think about regulating technology, there's a sort of battle going on between technology, law, and ethics. That's how I see it. Technology is about what's possible, law about what's permissible, and ethics about what's desirable. And ideally, you try to balance those three. That's the act of regulating. You try to balance those three in an adequate way. And as it comes to lawyers, I already told you that I don't really master the topic, but it's for lawyers very important also to combine people. So to combine people with a background in technology, to tell them what is going on in the blockchain. Because in my opinion, can lawyers really understand what's going on in the blockchain? And one position you can take then is that you just cherish innovation and say, let's get it on. It doesn't matter. But that's also not the most elegant way to approach it, in my opinion. So I think we should collaborate and we should join forces. And when I think about regulating technology, I teach my students and I use myself the following model. It's an iterative model with 3 questions. The first question is what, the object of regulation. The second question is why, for what reason would you like to regulate? And the third question is how. And then, because it's iterative, you come back to the what question, and the moment you have answered all 3 questions satisfactorily, you're done with it and you can know what to do about regulating the technology. And I will briefly touch upon each of the questions. First, the what, so the object of regulation is already a very difficult one when it comes to blockchain, because DeFi was already mentioned. I learned about it last week. So decentralized finance, that this is a quote. I didn't mention the source, but if you Google it, you can find who wrote it. Has joined fintech, financial technology, regtech, regular technology, cryptocurrencies, and digital assets, and one of the most discussed emerging technological evolution in global finance. That's quite a lot already. And that's most of this is financially related. But blockchain is much more, as the commissioner was also referring to. You can use it for lending, you can use it for insurance, you can use it for real estate, you can use it for royalties. So if you think about regulating the blockchain, what is the blockchain? What aspect of the blockchain you want to regulate? And I think Aaron was already mentioning also the NFTs. That's another thing. I wrote a short piece about it also, again, to try to understand what NFT actually is, because my first reaction was it's nothing, it means nothing. And to a certain extent, that's true. But also, if you take it from another perspective, you can say, well, NFT is something, and to some people, it's everything. So it just depends on your perspective. I think all perspectives are right. But again, in terms of regulation, what to do with those NFT, that's difficult. And cryptocurrency is another thing you can think about regarding the what question. And what you see a lot in existing regulation is that it focuses on the initial coin offering white papers, because that's something that you can easily grasp. And that's when the blockchain hasn't become uncontrollable in a way. So these are some considerations about the what question. And why? Why would you regulate? Well, for instance, money laundering, terrorism, consumer protection. So the regulation on white papers is primarily focused on consumer protection. But on a more conceptual, abstract level, trust in the digital infrastructure and the applications. Then the last question, how? It's sort of trivial. EU regulation you could choose for national law, or, and that's a very important one, never to forget, nothing. You can also do nothing. That can be a decision. So you might do some applications of the blockchain, for instance, for modeling the traffic of elderly people to places. If you use the blockchain for that, you probably don't need to regulate it. So that's a decision you can also take regarding regulation of blockchain, that you do nothing. And that brings me to closing. First, the observation, it ain't easy. If you look at those three questions, what, how, why, it ain't easy to, in general, it ain't easy to have questions to those answers to those questions when talking about regulation of technology, but in particular when it comes to blockchain. But I fully embrace the law plus tech approach of Thibault. So in thinking about regulation, we should consider how to use tech. So again, like I was saying before, join forces. And to quote, I don't know who said it before, but maybe someone here in the panel recognizes it. Blockchain code reveals, probably more than ever, the need for collaboration between law and technology, between policymakers, regulators, and blockchain communities. This may spark a pivotal moment in legal history, forcing the creation of a new paradigm that leads to the emergence of hide-or-ho unexplored synergies. Well phrased, Thibault. So thank you. Yeah, this is the last slide. I was taught by taught by a presenter person that you always have in the last slide who you are. So I'm Arno, Lodder, but you already know that. So thank you, and I'm looking forward to the discussion.
Well, me too, and thank you very much for such a great overview. I'm still waiting for the quote, from a music band. So you do have an hour now to squeeze one into your.
I had several. I had Forever Young, which is from Alpha Phil and Bob Dylan. I had TikTok People, which is from the Vaughan Brothers. I had What's Going On and Let's Get It On from Marvin Gaye. So there were quite some references to music.
All right, fair enough. So now we move on to the second part of this panel, in which I ask you questions. And again, I've tried my best to ask one question per speaker. The first question relates to the principles of regulations, and then to very specific actions we may want to take in the space. And the question is to you, Aaron. I think I must say that I'm a great one of your greatest fan on Twitter. You know, you have the tools on Twitter in which you could say how many likes you received and by whom. If you try it, I'm sure I will pop up in the top 10 because you do explore DAOs and NFTs and smart contracts in a way which is always very informative and put some light on the aspect that the other won't discuss. And what I see is that the battle between big tech companies and NFTs is actually intensifying, and it's sometimes not a battle anymore because they try to recapture the value of NFTs in a different way by creating some utility. And so I'm curious about the future of where everything's going on. And to better understand the future, you need to better understand the past. And so this brings me to my very first question. You've been heavily involved in the Wyoming blockchain bill. And it seems to me that the main objective of the bill, but please correct me if I'm wrong, was to foster the use and the spread of DAOs, and to create some legal certainty for people who wanted to create a DAO to know exactly how to do it. So the objective, at least the way I read the bill, was not to destroy them or to prevent people from creating DAO, quite the contrary. So is it fair as an assessment? And if so, how did you approach the subject to make sure that you could indeed help drafting a regulation with this objective to foster dynamism as opposed to hampering dynamism in the space?
Yeah, that's a great question, Thibault, and thanks for the kind words. I think thematically, the blockchain technology moves very quick, and what we've seen over the past year is just a shift away from use cases of blockchain that are primarily financial in nature, like that's the core thrust, to really the blossoming of Web3. And I think over the next couple of years, we're just going to increasingly see more and more use cases involving NFTs, non-fungible tokens, and also using blockchain technology to coordinate activity. That could be people pooling together assets to make investments of different sorts. That could be pooling together assets to build kind of modern riffs on companies or places of work. That could be just using a token as a way to create a ring around an online community so that they can prevent what we've seen if you spend a lot of time on the internet, which is kind of the rot that large online communities and frankly like large online platforms tend to experience as they grow in size and scope. And really at the center of this trend are decentralized autonomous organizations, or DAOs. The notion of DAOs is a bit amorphous, and people have different definitions for what a DAO is and the degree to which they're autonomous, et cetera. But I do think as a core concept, they're important. The purpose of the Wyoming law was just to hopefully lower the cost of setting up a DAO in a way that complies with US law. Conversations about how DAOs can interact with more traditional systems or the real world really started even before the launch of Ethereum. The idea around wrapping a DAO was first formulated, or I first heard about it at certain events that MIT hosted related to Bitcoin and Ethereum. I think back in 2015, a bunch of law professors, technologists, and others got together just to discuss the technology, its potential and its pitfalls. And this question emerged, if, let's say, an online group wanted to purchase a parcel of land or make an investment, how would they do that? And there aren't clear answers because the default rules in US corporate law, and I think that it's the same in Europe, although I'm far from an expert on European law, is that they resemble partnerships. And while partnerships are amazing, they have certain downside risks that most participants want to limit. And so the notion of wrapping a DAO in some sort of a vehicle was something that we explored. And because of the flexibility, at least in the US, related to LLCs and the ability of people to privately order their affairs with certain but very thin limited constraints, it seemed like a good vehicle to do that. We were one of the first groups that tried to do this in practice. We launched and helped support a DAO called the LAO, which was a wrap DAO. It was anchored in a Delaware limited liability company. The process of doing that took months. It took a tremendous amount of legal work. It was tremendously expensive. And the notion was that by flipping some of the default rules under LLC Acts in Wyoming and possibly other states, you could just drive down the cost of setting these things up and provide clarity that hopefully the public would want to know about when it came to the underlying smart contract-based systems that were implemented. The law is far from perfect. The legislative process, as many folks may know, you put a law that's drafted one way, it could potentially come out differently than what you anticipated, and I think there was a bit of that when it came to that legislation. But I think it's an important first step to just trying to really mediate this important point between how online groups and how digital assets will interact with more traditional systems. And I think DAOs are a nice vehicle to do that. And I do think the flexibility in the US approach, which has a heavy weight on private ordering and contract law, is really is a really great place to begin to anchor these types of vehicles and conversations.
All right, thanks a lot. So cost and certainty / rules were at the very center of the initiative, which leads me to ask you a question to you, Commissioner Peirce, regarding something that you mentioned already, the idea of creating a sandbox, and I guess eventually, why not opening safe harbors on the basis of the findings of the sandbox. It seems indeed that this is a great way to try out what might work. When using the word work here, what I have in mind is to maintain a balance between decentralization on the one hand, but also the incentive to keep on using the blockchains if you recentralize them a bit for the conveniency of applying the law. My concern, though, is the one of regulatory capture. And so this brings me to the following question. First, could you explain the logic of the safe harbor that you have proposed? I'm curious also if you could tell us why you think that the other commissioner, as you mentioned, are not so much for now on with the idea. And I'm curious as to how do you see the risk of regulatory capture here? And if you think we can manage the risk. To be very clear, what I have in mind is a company entering the sandbox and then trying to shape regulation in a way that will be good for that player and not for the others. So that's a lot of questions. So to sum up, what's the idea behind the sandbox? Why do you think it is not yet a success? And can we prevent regulatory capture?
Yeah, it is a big question. So in terms of the sandbox or the safe harbor that I proposed, the idea is to allow people to do a token distribution event without trying to figure out at the outset whether or not the token is a security or is being sold as part of a security, distributed as part of a securities offering. So the idea is that there's certain information that token purchasers would find valuable. They want to know, certainly what the code is, but they also want to know who the team is behind it, what the plans are for developing that network, what the token economics are. Is the team holding on to a bunch of tokens that it's going to dump at some point on the market? These are the kinds of things people want to know. And so saying if you want to rely on the safe harbor, you provide this information, you update it as you go along. It's backed up by the anti-fraud laws, which means if you lie, then we can bring a securities action against you. And then at the end of a 3-year period, you should sort of have that network decentralized. There's no one central party that has information that everyone else in the network needs at that point. And so the idea is that you would be able to exit from the securities laws altogether, or if you really are still centralized, then you could go ahead and register the tokens as securities, which does raise some issues, trying to figure out whether you're decentralized and then potentially having to register. There are potential issues around that. My colleagues haven't reacted so favorably so far. One I know has read it and responded to me in a public speech where she sort of indicated she thought it would facilitate more fraud. I actually think having some kind of a framework like this would enable people who are trying to do things the right way to use it and to be very transparent about what they're doing, which would be a signal in itself, though the safe harbor wouldn't be an exclusive one. If you could find another way to comply with the law, that would be fine too. Regulatory capture, I think, is a really important thing to be thinking about in this space. It's certainly something I think about a lot as a regulator, because how you craft rules can certainly favor certain parties and harm others. And so I think when I look at the crypto space, my big concern right now is that we're not regulating in a transparent manner. I think transparency is probably the best antidote. Transparency and public participation, I think, are the best antidotes to regulatory capture. So as an example, Chair Gensler has said to the exchanges, crypto exchanges, come in and register with us. Okay, so we all know that there's no way for them just to come in and register under the existing regulatory framework. Something has to change. Either the crypto platforms have to change the way they do business, or we have to make some adjustments on our end. If those adjustments are made in connection with one-off conversations with an individual exchange, then I think what happens is that exchange very cleverly structures those regs in a way that works for that exchange and nobody else, which is why I'd like us to be doing a rulemaking, actually, or an exemptive process where we are getting comment, notice and comment, so that we can get a variety of viewpoints and get more people involved. Unfortunately, the approach that we've taken so far with no action letters, again, this is a kind of pilot program, a kind of sandbox. Someone can come in and say, here's what I'm trying to do. These are the conditions I'm placing around it. Those conditions are negotiated. Again, that's all done in private, and that comes out and that becomes a template for others. That's not good. And then our enforcement actions can also serve as kind of a negotiation where, again, conditions are placed on the settlement, and those conditions then become a template for future settlements. And those are really problematic from my perspective. I mean, I get why individual entities decide they want to settle and try to craft the settlement in a way that's most favorable to them. But for a regulator, it should cause us great concern, which is why I've continued to say we need to lead with our regulators' foot, and that regulatory process in the United States is very structured to get public comment, to get lots of people interacting with each other. So that's a long answer to a long question.
No, yes, thank you very much. And something I always found to be very effective after agencies receive those public comments is to actually publish a summary of what has been said to the agency. So not to give the feeling that, this was just a trick, so to pass a regulation without even reading the public comments. And I know that this has been done in the US numerous times, and I find that to be great. You mentioned the issue of fraud, and this actually leads me to ask you a question to you, Lukas. What we know from Chainalytics is that last year, 0.15% of blockchain transactions were tied to illegal activities. You could say this is way too much, right? It used to be 7% just a few years ago, so it's on the decline. And you could also say, well, that it's just 0.15%, right? So most blockchain transactions are actually perfectly legal in nature. And yet it seems to me that MiCA, which is coming in Europe, tackles the issue of exchanges and will, according to at least the draft version, impose that exchanges have to ask the real life identity of the persons using those exchanges to convert tokens into fiat currency. And I could see why, indeed, if you impose that, it reduces the incentive to use crypto for illegal purposes. But again, knowing that it's only 0.15%, I'm wondering if we shouldn't introduce something more in MiCA that would be potentially even more effective. And what I have in mind here is not what the exchange is doing as a way to just exchange tokens into fiat currency, but looking at their practices as an exchange. Let me give you an example. Let's imagine we have only one exchange or two exchanges, very, very powerful. You could see that they would be able to coordinate and to say, well, we have decided that now the fees to convert tokens into fiat currencies are 20%, right? This will be a bad behavior, potentially anti-competitive. And so my question is the following. Do you think that we should regulate the activities of exchanges on top of just regulating the way they set up the actual exchange of token into fiat currency? Or do you think that maybe just legal enforcement is enough and that's not the role of regulators to regulate activities of exchanges?
Thank you for this long question. I'll try to break it down into some bits that I can do. So I'll start with the first one on the fraud risk and the need to identify players and the question whether the MiCA captures this sufficiently. I think it's not so much the MiCA, but more the anti-money laundering rules that you would have to look at here, really, because the crypto asset service providers, and exchanges are crypto asset service providers, are obliged by anti-money laundering rules to identify the persons that they onboard and that they're allowed to trade. So that risk of people using cryptocurrency exchanges anonymously should now be addressed with anti-money laundering rules. I won't comment on the figure of 0.15% fraud because I can't verify it. I would just say if this is really true, if this is the only fraud that occurs in the cryptocurrency space, then I think we are more or less where we are also in other areas of the economy, but I can't verify this. Yeah. I will say this on your hypothetical example of one or two exchanges abusing market power and your question whether we need legislation for that, my answer clearly is no. I think that would be completely over the top to adopt a specific law for cryptocurrencies exchanges market power, because we have in Europe and we have in the United States of America very flexible, principle-based antitrust rules, and Judge Zilgalvis presented them very eloquently in the beginning. Article 102 of the treaty on the abuse of market power stipulates very clearly that if an entity that is in a situation of market power abuses that market power, it is subject to fines and also to civil law damage claims in court. And you can have collective dominance by two players, for instance, that would perfectly be caught by Article 102 of the treaty, or you could have Article 101 of the treaty, which prohibits anti-competitive collusion between two competitors. So if in your example, the two exchanges would collude over prices to the detriment of users, that would clearly be caught by Article 101. We don't need a specific legislation for that. I think the merit of the MiCA, if I may come back to it, is that it really tries to harmonize the different approaches that our member states took to the classification of cryptocurrencies, to the requirements they put on crypto asset service providers, and by harmonizing these rules in a comprehensive way, we are creating not only a level playing field, we are not only preventing forum shopping, but we are in particular helping the innovators, because you cannot scale up in Europe a venture that is active in this space and that faces 27 different standards for what is a cryptocurrency.
Well,
yes. Does this answer your question?
Of course, and it's fascinating because we go back to what Arno was saying, right? The cost and the rules. You lower the cost and you simplify the rules, which is your objective. So thank you very much. And also it creates a bridge to the next question, which is wonderful, which is to you, Judge. So if indeed legal enforcement is enough, then we have a question of expertise within the court, right? My question is very concrete. Is there any technical training offered to the judge of general court and the Court of Justice? If not, do you think this is something that is coming? And I guess it eventually comes down to the following question. Let us say that there is no technical expertise, and I think you can't ask a judge to know how to code in Solidity and C++. Why not? But this is something for a different day, which means that the court will need to ask external expertise, right, from someone who knows about all those questions. But of course, if you know nothing about it, then it's hard to know if the expertise that you receive is accurate or not. And so do you think we need some standards there? Like they've done in the US with the Dober case in 1993, in which they say, well, those are the criteria for external expertise to be valid before the court.
Thank you for the question. I mean, first of all, on the expertise of the judges, I mean, it's up to the judges to acquire the necessary knowledge when working on the case. And it's also up to the parties to explain any technical aspects relevant to their case. That said, we're at a fairly advanced stage of our career when we come to the general court or the court. So everyone is coming with expertise in perhaps even multiple different areas, and contributing that to the discussion in the chambers between the judges. We also have regular meetings where judges present an area of interest, which, for example, I will be presenting on some of these technological developments that we're talking about today, and others on the digital currencies. As well, you mentioned the expertise that can be introduced during the procedure. The rules of procedure of the court allow a expert report to be commissioned as part of a measure of inquiry. And the parties then are always able to counter the report of the expert and also to help the judge through clarifications to understand technical aspects properly if it's felt that they don't in the exchange. You mentioned the Delrahim case in the US. In the EU, the principle that prevails is that of the unfettered evaluation of evidence. And though there is no legislation at EU level governing what the concept of proof is, any type of evidence that is admissible under the procedural law of the member states in similar proceedings is in principle admissible, which is what the case law says. And according to the generally applicable rules on evidence, the credibility and the probative value of a document depend on its origin, circumstances in which it was drawn up, person to whom it was addressed, and the soundness and the reliable nature of its contents, which is also a question of the, level of expertise, if this is, let's say, an expert report. And then a final comment, we do make a limited judicial review of technical aspects. It's a general rule of the courts that there's a comprehensive review whether the conditions, for instance, applying the competition provisions of the EU treaty are met, but the court does not go into replacing the complex technical or economic analysis that was done, for instance, by the commission. That's not our role, but obviously if it is found that there's an error in law, an error in fact, or that this was not applied in a credible way, this can be the basis for the court to question this.
All right. Yes, thank you very much. It's very clear. I do want to ask a last question to you, Arno, regarding the approach. And I can tell you this is going to be a controversial question. The question is the following. Let us presume that people know what they do when they enter the blockchain space, right? And use a smart contract, buy an NFT, enter into a DAO. Let us assume that they know that they are using an application which is running on top of an infrastructure which is immutable, right? If so, you can make the point that people know that the right to be forgotten can't be enforced within the blockchain, or at least it's really hard. And yet they've made a choice to use the blockchain. So in a sense, you could say that they are fine with the idea to get a service that they like in exchange for a right that we may think they might like. Now, the question is the following. You have written the 10 commandments of internet law, and you say that one should be for internet lawyers to emphasize that convenience may come at the price. And I think this is exactly what we see in a very clear-cut way with blockchain. So my question is the following. If people are indeed aware of what they do when they use a blockchain, and yet they keep on using it, should we revise what we lawyers consider as being fundamental rights and potentially demote those rights as just regular rights because people do not see them as being fundamental?
Well, I don't think I could or would say that fundamental rights should be in any way demoted. But I think a part of the whole conception of fundamental rights is the focus on the individual. Obviously, in a societal context, there are actions of the individual that can have implications for society, but an empowerment of the individual to ensure that he or she is not victimized, that he or she has a right to choose employment, right to healthcare, and so on. Mm-hmm. So I think, and this then starts getting me into a little bit of a speculative and abstract thinking, because such a case with the decentralized technologies, the distributed technologies, has not come up yet to my mind, at least definitely to the European level. Yeah. I mean, I think there has to be definitely an evaluation of what the individuals themselves were expecting to get when utilizing the technology, whether they understood what the implications were, that this was not explained to them in some kind of deep legalese which people could not comprehend. And if so, is there a reason to take an approach that they should not be able to do this because they are compromising themselves some right or some protection? Because obviously some type of paternalism that we know better than you do on the way that you should be exercising your life on the internet, to my mind, is not within the spirit of fundamental rights. So it would have to be this type of evaluation, to my mind.
That's fascinating. And so, because indeed, if you say a right is fundamental, then it means that you should have no trade-off, right? People should be able to enforce the right no matter right. So that will ask you the question to you, Arno. What is your take on that? Do you share the same view? That I mean, just to be clear, I'm taking blockchain as an example, but you could take all the services that we use with big tech companies, right? We are aware that we compromise privacy, and yet we keep on using those. So what is your take?
Yeah, to begin with, fundamental rights, they're not absolute. So you can have maybe the right to torture is an exception to a fundamental right where there's no exception. But normally there are exceptions to fundamental right. As it comes to the right to be forgotten, that's also often misunderstood because it's also not an absolute right. You have to weigh it, you have to balance it with, for instance, freedom of information, freedom of speech, etc. And as it comes to blockchain and GDPR, I never really understood that people were trying to construct a sort of controller into the blockchain, because if you have a blockchain that's decentralized and there's no central authority, there's no controller. So you cannot apply the GDPR then. What is an interesting question to me, because I did a lot of research also into information requirements in consumers and that it should be informed. And I think the European Union has way too much information requirements for providers of services, and that you should be informed about the core aspects of any contracts you enter into. The moment you use a blockchain and you are sort of lured into it without having given the protection you would expect it in the context of consumer rights, you might run into a problem. But how to solve it, that's a different issue. And I don't think that maybe it's in the end then, as I think the judge was also referring to, it's sort of responsibility of the users. So maybe we should then, because the how in my three questions is also, for instance, that you inform the public. So maybe you should inform them about the consequence of the blockchain, because in my view, one of the charms of blockchain and smart contracts is that they execute automatically. And if you start to question that, you really touch upon the core of a blockchain. And of course, there can also always be exceptions that are very unreasonable cases, but given that you can find the other party that acted unreasonable, it still is a bit odd to, for instance, go to court to discuss something that was in a smart contract. So I think these are very interesting questions.
Yeah,
I don't have the answer, but what I don't want to suggest is, for instance, the internet is distributed and you have the information society service provider that you can act norms upon. With the blockchain, it can be different if it's a proper blockchain. And I think if you centralize it, in my view, but maybe that's my misunderstanding of the blockchain, it's no longer a blockchain. Okay, it can be a chain of blocks, but characteristic for the blockchain, I think also the distributed nature.
Very much agree. Looking at the subject from a Darwinian perspective, right? You want to maintain what differentiates blockchain from the other species, namely centralized ways of transacting, otherwise you disappear. So thank you very much for that. It's time to move on to the second part of the panel, and then we have a lot of fascinating questions and I would like to address them all. Pēteris, the question is to you. There is a court decision which was very interesting in the US published last year in April of 2021, American Corp versus Bitmain, in which they disagreed regarding the size of the block in the blockchain. They forked the blockchain and one group assigned the other. The court found that the practice was not anti-competitive, but that's not my point. It could have been that the court would have been in a position to say that fork of the blockchain is anti-competitive, and you know what? All forks are anti-competitive, because what you do is that you duplicate the blockchain and divide the value following an agreement. That decision, I think, would have been a disaster for the space, because forks are, what makes blockchain dynamic. So all that to say, I might be wrong, but my point is the following: court's decision has a very important role to play in the ecosystem, and that's why I refer to those court decisions as being regulations. Of course, they are not, but they play an equally important role. My question is then, do you see blockchain survival as one of your objectives as part of the general court, should you ever have a case before you?
Okay, well, I'll start perhaps with the second part of the question and then go to the jurisprudence, to the case that you mentioned. I mean, I would say that I think that promotion of an innovation economy with a high level of technological development is in the interest of citizens and enterprises and the society as a whole. That said, we should be technology neutral. Heaven forbid that I'm deciding as a judge that machine learning or artificial intelligence or blockchain or big data should be the priority of the European economy or research. That said, we should make sure that the interpretation of European Union law and the way that the rights of citizens and enterprises are protected is something that fosters technological development in the interests of the economy and society. The court case that you mentioned, I mean, it's a little bit based, I would say, I'm less of an expert on US law, but on the rule of reason approach, which is coming from the Sherman Act. EU competition law does not recognize a rule of reason as such under Article 101.1, a weighing of the pro and anti-competitive effects of an agreement. These are weighed under Article 101.3. But I would mention, I think in this context, Metropole versus the Commission, where they said there's not such a rule of reason because firstly, there's the bifurcation of Article 101 between the first part and 3. And then secondly, that Article 101.3 would lose much of its effectiveness if that was only where we weighed when we were considering whether the agreement satisfies 101.3. And then what I think is very relevant, this is probably a little bit legalese for a lot of people, but I think which is very relevant and interesting for our discussion, their third point is that what the EU jurisprudence demonstrates is that a restriction of competition cannot be found in the abstract. It generally requires a careful analysis of the relevant factual, legal, and economic context on a case-by-case basis. Yeah. So this is why I didn't draw overall conclusions on the blockchain could be facilitating a cartel, the blockchain could be facilitating agreements, prohibited anti-competitive agreements, because it will be looking at the case-by-case basis. The economic context would inevitably be looking at through the same, for instance, Article 101.3, the benefits that the technology or the collaboration between the enterprises could bring to consumers, to the economy. So, I mean, there's a little bit of a difference between the way that our American colleagues approach the analysis and the way that we do in EU law, but a certain, how to say, commonality that you do have a weighing of the positive and the negative, but in a different way, and in our case, through a case-by-case analysis.
Yes, thank you very much for putting that so clearly. So if we do have students in the room, there is no rule of reason in European competition law. You read sometimes the opposite, but what you do is that you say the practice is illegal under Article 101, paragraph 1, and then you may exempt it under paragraph 3, which is a different logic. Going back to a subject we've been discussing in the two panels, and the question is for you, Commissioner Peirce, the one of whether a token is a security or utility or something else. What again, I see from my competition background is that the ability that you may have to do an airdrop, offer the token, may actually allow you to attract users, although they cannot derive something useful from the service in and of itself because there are no other users, right? So it's an important element of competition. But of course, if you say that a token is a security, as you mentioned already, then comes all the regulations and may create an incentive not to acquire the token and may slow down competition. So I'm curious as to whether competitive dynamics is something that you take into account at the SEC, maybe working or being in touch with the FTC in the regard. And is there anything coming in the space in 2022 as to this type of regulation, or at least to the best of your knowledge?
Well, to your last question first, I mean, the agency puts out a regulatory agenda that the chair lays out what his agenda is upcoming. And there isn't anything crypto blockchain specific on that agenda. Competition is certainly something that we think about in the context of our rulemakings. We're required to think about it in that context. But I mean, I think this ties again to your last question. In enforcement actions, competition isn't really front of mind, which is understandable. I mean, we're pursuing a particular violation, but I think the problem comes when you structure a settlement that maybe has the effect of precluding competition later. In terms of, we do interact with our colleagues at FTC and DOJ when it comes to competition issues. Chair Gensler has expressed an interest in these particular issues, but again, our mandate is primarily the one that I laid out at the beginning, which is facilitating capital formation, the integrity of the markets, protecting the integrity of the markets, and protecting investors. Obviously, competition has a role in protecting investors, but it's not our primary mandate.
Yes, sure. Thank you very much. As we know, prediction is hard, especially when it's about the future. And yet there is one person that I trust for prediction on the panel, maybe more, but actually one person I want to ask a question to. This is you, Aaron. I'm curious about where you think the NFTs market is going. And if you think that regulation has a role to play here, do we need regulation? Is it already too late? Is it way too soon? So what's the future and what's the role of regulation in shaping the future of NFTs?
Yeah, I mean, I personally think if we zoom out 5 years, that NFTs, and we probably won't even refer to them as NFTs at that point, will be the largest portion of the blockchain technology sector. I think it's something that resonates with consumers. It's helping online groups to form in ways that are not based on a platform, which I think is incredibly important, especially when you view it from a competitive lens and see some of the larger Web2 platforms where lots of these groups congregate today. I also think it's incredibly supportive to artists, creators, and other people that are their primary means of production is creating intellectual property. And you're seeing them, and one could argue that you're seeing those individuals or groups getting more fairly paid for their work without, again, having to be tethered to a large intermediary or platform. And I think they're fun. And I know that that's maybe overly simplistic, but I think that's important. It's something that's resonating with consumers. And I think it has kind of a mass market appeal. And if you look at metrics, and there's plenty of places, and this is the benefit of blockchain, we can track this type of information, even as we've seen participation in decentralized finance platforms or other platforms kind of level off or slow down, you're seeing kind of continued explosive growth with NFTs. In terms of regulation, I personally just think we don't fully know what the risks are yet when it comes to NFTs. I think they're like all emerging markets, there's questions and concerns, similar to concerns that we've seen with other token-based systems, concerns related to AML, know your customer related matters, and the degree to which some of the trading activity may not be valid or potentially fraudulent or have money laundering dimensions. I think that there's more heady conversations about fractionalization of NFTs and whether that's a good thing or a bad thing, or can create certain issues. So I think, the right approach is wait and see. And I do think it's something to pay attention to, because my instinct tells me that this is what the market will increasingly look like. It will be a lot less, financial, at least on the front. There's always a financial element when you're talking about crypto, but it will be less about kind of replicating or re-replicating, deep financial systems, and more about kind of exploring how different creators and online communities can work together in more productive ways.
Yes, thanks a lot. I want now to zoom out a little bit and talk about the tech behind NFTs, smart contracts, and that's a question for you, Lukas. I believe that you are concerned about existing or forthcoming regulations hampering the development of smart contracts. So to be very concrete, an example could be that if you impose that certain specific contracts should be on a piece of paper, then of course you basically say you can't use a smart contract, which might be bad for their growth. But I'm especially curious about forthcoming regulations, such as the AI Act, Data Act, and potentially, if we have such a thing coming, data sovereignty obligations. To be concrete, the AI Act, such as it is drafted right now, it's not the final version, but does say that it covers expert systems. Smart contracts are expert systems, therefore they are covered by the AI Act, and it means that it comes with lots of obligations. So my question is the following. Is there any danger that those regulations could hamper blockchain and smart contract development, or do you think we're all clear? And is it fair to say that indeed one of the objectives of your team is to capture and target and identify those potential regulatory barriers to try to see if we should maintain them or, on the contrary, get rid of them?
Well, I think I start with the last point. It's indeed fair to say, I think, that within the European Commission, I do work in the part of the European Commission that's in particular focusing on the development of technology and pro-innovation approach. So we see a little bit our role in our unit is called the Innovation, Startup Innovation and Blockchain Unit, as the ones that see to it that regulation is in a balance with the need to sustain innovation. So that is absolutely true. We are not alone here. We have, thankfully, the support from the European Observatory for Blockchain. This is a pool of experts and a think tank of the European Commission that monitors not only at the European level, but also at the national level, regulatory developments that can affect blockchain technology, that publish regular reports, trend reports and thematic reports on these issues, amongst others on the application of the GDPR to blockchain, blockchain in the healthcare sector, where you have a lot of regulations and so forth. So we are not alone here. And finally, but last but not least, Thibault, we're also grateful for the support of academics like yourself in writing studies on issues such as the smart contracts. Now, I think we can generally say that colleagues working on financial regulation for smart contracts, etc., are very much aware that blockchain is a very special animal. And I must say that we have found a lot of understanding in our discussions that legislation has to be drafted with the pro-innovation principle in mind. For instance, we just heard about the non-fungible tokens, which are extremely interesting in terms of innovation and in terms of helping to align the value creation with the value capture in art. We have carved them out from the MiCA. So non-fungible tokens are not subject to the type of same regulation that we would apply to the trading of securities in a tokenized form. And we also were able to create a safe harbor for initial coin offerings in European regulation. So I think the things that we've talked about today, you will find them in the MiCA. And that has very much to do with the fact that we try to achieve a certain balance in the regulation, not to regulate too much, to be careful and not to go too far. Smart contracts in particular, Thibault, are a tough cookie because smart contracts, unfortunately, are called contracts, although they are not contracts. So starting with this very confusing terminology, you have a lot of lawyers that are totally excited about smart contracts because they believe this is an agreement like two people signing a lease contract and putting the signature on it. They are not, of course. They are bytecodes in a block. They're bytecodes in a block, and they execute things that can be in a contract. So when you start looking at it that way, you understand that actually all of these problems, and in many, many articles that have been published about smart contracts and the law, these problems, to a certain extent, they solve themselves. A bytecode in a block cannot represent a contract because people can't understand what it is about. They need a prose contract or they factually conclude a contract. But the smart contract can be tremendously helpful in the machine-to-machine economy, which is the future, which is the Internet of the Things, economy 4.0. So when we talk about regulating smart contracts, we essentially talk about creating standards that achieve the interoperability of smart contracts, and they create a certain minimum requirements for smart contracts to be stoppable, to be auditable, but definitely not to go further and harmonize civil law now and start creating a specific set of rules for how smart contracts can qualify as legal agreements. I think that would be over the top. So after a little bit of this rambling, very briefly to your question, I think on smart contracts, you can expect that we will come forward with something very targeted, very limited, setting a number of limited essential requirements for trust service providers that create smart contracts. But beyond that, the existing law is sufficiently flexible to answer the questions that are being raised in many, many academic articles, which I love to read, but which sometimes also raise questions that in practice, I hope, will not really create problems.
Yes, and so just to be clear, you said that we can expect something very targeted, right?
We hope you can expect. We're in the process of working on something.
All right.
As Judge Zilgalvis can certainly confirm from his time at the European Commission, we work thoroughly, but it also takes a bit of time.
All right, thank you very much. I think it's time for me to move on to the Q&A. We have lots of questions. I've put a few here. First question, I guess, is for Commissioner Peirce. The question is the following: over the top 100 crypto, how many you think are unregistered securities?
Love the question. Everyone's always trying to get us to say which crypto are securities. I mean, I will just say that I don't typically comment on those kinds of questions because, one, my views are quite different than my colleagues. So a crypto asset might have been sold as part of a securities offering, but that doesn't necessarily mean the crypto asset itself is a security. So that's one point. And the second is these are very facts and circumstances dependent. I've argued that we should be doing a better job to provide some guidelines so that people can think through that question. And we haven't done that, but if you relied on what I said, you might not get the majority view at the Commission.
Yes, and I guess the following question is also for you, but we may have a similar answer. Let's see. Someone is asking you whether, so in case of uncertainty, you have to do the filing before the SEC, and the person is raising the issue of the cost that it may represent, and is therefore asking if you think that the Consumer Financial Protection Bureau wouldn't be a more effective way to enforce some of the regulations in the space.
Let me just say, I doubt that it would be any cheaper.
Great answer. Thank you very much. The following question, and it's, let me see. Well, let's see who wants to answer that one. I think it's a very important question. Someone is asking whether to review the code of a blockchain should be part of the work of regulators, or if we should simply approach the subject again from the perspective of, finished products in a certain industry with a certain specific applications. Anyone on that one?
I think it's a matter of timing. It's can be problematic to review the code because if the blockchain is there, it's there. So you and who's going to impose such a norm upon the one who wants to launch a blockchain? You can always go to a country where there's no law then, for instance. But I think it's what you can do is that you have sort of certification mechanism that say, well, if you let us revise or look into the code, then you can have certification that. So these kind of mechanisms I think could be feasible, but just in general revision of the code as an obligation, it's not very workable. I think.
Aaron, I think you wanted to answer something.
Yeah, I mean, I think that, you know, there's a natural instinct to think about some of these issues in order to, you know, kind of limit potential exploits, consumer harm if there's some technical issue with it. But I think at its core, when you start to think about reviewing code or a government entity doing it, it's in a command and control structure.
Yeah.
I think we've seen plenty of industries that operate via command and control structure. And over time, the level of innovation tends to drop when there's that type of a regulatory approach provided, or at least there's at least arguments to that effect. And obviously people can debate that. So I think here, when you're dealing with a fast moving, very dynamic ecosystem, it probably does not yet make sense to do that just because you don't know exactly how to evaluate it. I think number two, and you touched on this, I think at different points today, Thibault, just having the internal competency in order to actually perform that review is difficult because it's such a new industry. You know, very well funded technology companies and projects that want to explore this can barely find developers to you know, work and build the bleeding edge of technology. The notion that the government would be able to enlist a sufficient number of people to review the tech is pretty low. And I think it also runs the risk of actually avoiding some form of tech neutrality. I think once you add review functions into it, there are certain biases that the agencies or the reviewers will introduce, and that creates some issues. And last, I just don't even know what benefits you're really going to get from that. You know, just in general, you know, these dynamic markets where you have the ability, it's all open source code, people use it, they can, if it's not working, they can move to another system, they can fork it. You kind of see that process, which is very organic in nature, working, and systems seem to get more stable over time, or at least that's the thesis around that type of an approach.
Thanks a lot. I guess the next question is for you, Lukas. It asks whether or not, according to existing EU regulations, but I guess also the forthcoming one, is there a risk for forum shopping when it comes to tax law and cryptocurrencies?
I think I touched upon it briefly before, is that fiscal legislation remains a prerogative of the 27 member states. So this is one of the areas where the member states have not transferred powers to the European legislator. We have very limited possibilities here. We harmonize, for instance, the basis for calculating value-added tax, but we are not harmonizing the tax itself. So naturally speaking, as long as there's no harmonization of fiscal laws in any area of the economy, you have differences in taxation between member states, and there is a fair competition between them to attract businesses. This is not blockchain specific, that is just specific to how the European Union works. And I think even in the United States of America, you have different fiscal incentive schemes to attract businesses from one state to another. I don't know whether Commissioner Peirce would agree with that, but I think in Europe, this is just inherent in the fact how we operate, and you could certainly have some competition there. So I wouldn't exclude that.
Thanks a lot. I see a yes, maybe. I want to ask the following question to Arno and to you, Judge. How can we justify legitimacy of applying EU law to decentralized communities? Any thought on that? And I guess the same question will also be valid, you know, how could you justify applying US law when you talk about the layer one of a blockchain, not just an application, but a layer one, which is all over the world? It's not easy.
But it's the same with peer-to-peer networks, for instance. So
yeah, same.
It's a peer-to-peer network, and you had I think Napster was centralized, and then Kazaa and Pirate Bay were decentralized. You can so for instance in e-commerce law, where the service providers established is where the law applies to them. So you can use these kind of mechanisms. So but with blockchain, I don't really know if there's always a party who is responsible for the blockchain. So for instance, in case of Bitcoin, I don't think there is a party. So who are you going to impose the norms upon? That's, I think, very difficult. Maybe on the people using it, but it's also from privacy perspective can be really problematic. So for new blockchains, it can be different. That's why white papers are interesting to target upon, because then the blockchain isn't really there. You mentioned also in your book, so the difference between the blockchains that are already there and that are not there. And I think before they're there, you can do things, but if they're there and they are permissionless, decentralized, if I say it correctly.
Public permissionless, yes.
Public permissionless. And then there's not much you can do, I guess. So.
Aaron, but then I want to ask you also following question. Judge, maybe if you want to comment on that? You don't have to.
Yes. I mean, I was going to say, I mean, there are individual, tangible people and tangible enterprises involved in engaging on the blockchain and other decentralized communities. So the fact that it's decentralized doesn't mean that either their rights or obligations end. And I'm old enough to remember some of the, I would say in this case, hype about the internet, that the internet knows no borders and you can't stop it anywhere, and the internet just does what the internet does. E-commerce is regulated, not always. Perhaps this is the model that we want to follow. It can be done better and better, but I think regulators and the judiciary in Europe and in other parts of the world are also realist and pragmatic in what they can control in the interest of a citizen or enterprise, and what, of course, sometimes is beyond their control. And people are not going to be trying to tilt at windmills to tell the rest of the world to just simply do something.
I mean, that's interesting. So these are the users. So it's not the blockchain as such, it's not the technology. So that's, I think, a distinction that's important to make.
Yeah, indeed. We come back to the question, okay, we can identify, but if there is no control, no liability. And so, yeah, it's a bit of a dead end. I do have a last question to Aaron and to Commissioner Peirce. Is code free speech or speech, I suppose, and is it protected under the First Amendment?
I'm happy to take that one, at least as a first swipe. You know, in the US, there have been a handful of cases that have addressed this exact issue. There's not a full degree of clarity related to it, but I think that there are strong arguments that the creation and publication of software is protected by the First Amendment. I think the challenge, and this is where nuance I think has to come into play, that general principle, which there's support for in certain circuits, is not absolute, right? There may be some exceptions to that. And the challenging questions, I think, when it comes to this intersection between First Amendment rights and also the development of software, is this distinction between creating the software and implementing it. That's one area. And then the second one is when a system can be used for both legal and illegal purposes. First Amendment protections do not extend to things that are patently illegal. At least that's the clarity, or as much clarity as we have with some of those cases. But it's those ones in between that I think are challenging. And those types of questions were the questions that came up with in the context of peer-to-peer networks and copyright infringement. Cases went all the way up to the Supreme Court on contributory liability theories. And the Supreme Court said, you can't be held contributory liable if the system can be used both for lawful and unlawful purposes. I think there's some wisdom in that approach. And I think here, that may be something that people should consider for purposes of First Amendment protection.
Thank you very much. Commissioner Peirce, is anything you want to say?
Well, I mean, Aaron certainly knows the case law better than I do. I just say that I have, I will certainly approach these kinds of questions with great concern if we try to start regulating coders for simply putting code out there. So important issues for people to be thinking about, but I think it's dangerous territory for us to wander into.
Yeah, and yet we've some part of the academic community, going in this direction. So
yeah, and I completely agree with that. I think it's a very slippery slope when you start to go down to software development, because I just think increasingly software development will be more pervasive, and upcoming generations, it'll be like, the way we learn how to write essays and articles and use language to express ourselves. I think increasingly we're seeing people use code in those manners too, and some bad early case law could really derail or create a world that we may not want for our children.
Thanks a lot. I don't want to finish up too late, but if I can just ask each and every one of you to, if you have anything you want to say as a matter of conclusion and what to expect from you in the coming month or years. We start with you, Judge.
Thank you very much for organizing, I think, this very useful discussion, and for all the investment that you've made in the academic world and the analysis of the decentralized technologies in the law and competition law. And I think I can't make any pronouncements about what's going to be coming out of the General Court or the Court of Justice, but I mean, hopefully we'll be having an even more astute reading of the aspects of the technologies that are important for the jurisdiction.
Thank you very much. Arno?
Yeah, so when I first encountered blockchain, to me it was sort of internet on steroids. So that's why I was really interested in the phenomenon. And I'm looking forward to write a piece with you in the next coming year. So that's what I want to do. And I have a quote for you because I went to the barber yesterday that you must recognize. I hope. I'm just a boy with a new haircut. Do you recognize?
Of course, it's the best band in the music history, of course, Pavement. All right, thank you very much. Aaron.
I mean, I've been very, very interested in this space for quite some time. I think I'll continue to just explore my interests in lots of different ways. So,
yes, thanks a lot. And if you haven't checked Tribute Labs, it's fascinating. So you should do that. Commissioner Peirce.
Thanks, Thibault, and to the rest of the panelists for an interesting conversation. I'll just say that if anyone has thoughts about how we should be approaching regulation, don't hesitate to reach out. Commissioner Peirce at sec.gov.
Thank you very much. And Lukas, the final word is yours.
Thank you very much for having me. I just say this, we would like to launch a regulatory sandbox for blockchain after the summer. So all of you who here are interested to test some innovations, ideas, blockchain in a sandbox, we're going to launch that after the summer. So the tender will be out soon. And we hope it will contribute to providing more legal certainty in this space. Thank you so much for having me.
Wow, I have no idea you wanted to announce that, so that's a big.
It's a good moment,
final...
no? At the end, boom.
Exactly. People were never gonna believe that.
I got my moment. Thank you so much.
Thank you very much, everyone. Again, you can check the Amsterdam Law Technology Institute website, where we put the video of this conference in just a few days. To all the members of the panel, it has been a blast and a thrill. So thank you so very much. Anyone out there, thank you. Have a good day. I see a lot of positive messages in the chat. So thank you. It means a lot. And I'll see you very soon. Bye-bye.